For listing.
For listing, my lord, on Monday.
Okay.
For admission.
My lord, same prayer, my lord. One pending MSc appeal, my lord.
For motion for Monday, Lordship.
Monday, or take it a little later. Monday.
Lordship, Monday, Lordship.
Monday.
Oblige you, Lordship. And one CRPIO for Wednesday, Lordship. Oblige you, Lordship.
Made please, your lordship. Lordship, I beg to mention item number 15 of today's list, my lord.
1-5.
But what had happened in this case, the one senior counsel is supposed to argue the matter. He has some personal difficulties today. Let the matter be taken up on Monday, my lord.
Monday.
Fresh matter, my lord.
Come in the supply list. Okay. Monday or little later. Okay. Monday. Adjournment. 6 and adjournment.
Monday, my lord.
Monday.
Much surplus.
Yeah.
Like to mention item number
2. Yes.
the arguing counsel is having some personal difficulty.
No problem.
Arbitration matter, my lord.
Arbitration.
Pending.
Arbitration. After a week. After
Next.
your good name, please.
Yes, Priyanka Das.
With counsel. 6 and adjournment with the personal difficulty of the leading counsel. Full stop. This is the matter after a week. On a date to be fixed by registry? Or you want a date to be fixed?
My lord, it can be taken up in next week, my lord, because the pending.
Okay.
I filed an
Okay.
application for
Should we fix a date or
Yes, Lordship.
27?
27.
Next Friday.
Fine.
Okay. Next Friday.
Yeah, please, your lordship. I beg to mention item number 19, lordship.
Yes. You want to
I beg to mention item number 19, lordship.
1-9.
Yes, lordship. In this matter, I have filed affidavit, lordship. Not take the record.
Hmm?
In this matter, I have filed affidavit, lordship, regarding
Okay.
substantial question of other substantial question, lordship.
It will be, you
Not
want to
take the matter. So kindly list the matter on 27, lordship, with the affidavit, lordship.
Current counsel submits that an affidavit has been filed today. Praise for listing the matter after a week on 27th. List on 27th. Yes.
Please, lordship. I beg to mention item number 10 of this list. Can it be in next week also?
My lord,
Time for the respondent.
I appear for the petitioner. There's some problem. In fact, on the previous occasions, the records of the appellate court, first appellate court and the trial court were called.
Mhm.
Initially, the appellate court records were received, not the trial court record. Then again, a reminder was issued. Now the trial court report has, record has come in the form of scan copy. But there is an office note dated 16/3/2026. There's an office note which says that there are, most of the pages are illegible and torn out.
Mhm.
So my understanding, my lord, is that since there is an order, previous order whereby records were called for and it needs to be produced for adjudication of the case. So my learned friend not objecting, the original records, I think, because it's a disposed of case, the appeal has been disposed of.
Mhm.
So the original records should be called here.
Can be. Nothing is pending there.
Nothing is pending there. And if original records are called for, then obviously I think it will take some time. So let this matter come up after Bihu vacation. In the meantime, the records can come. I'll just tell the case numbers. The case numbers are title appeal 30 of 2024 and title suit number 37 of 1990.
Learned Mr. Teacher Property Learned Counsel for the petitioner submits that those scan copy of the
PCRs.
appellate case, the appellate case, appellate record as well as the trial record, trial court record has been received, but many pages of the trial court TCR are not legible, and accordingly submits that as it is a disposed of matter, the original may be called to. Mr. Purcaster, Learned Counsel for the other side, concurs with the said submission first. Accordingly, call for the original TCR of
Title suit number 37 of 1991.
1990 was very old.
Very old.
And appellate also? Appeal
Yes, title appeal number 30 of 2004.
from the courts of the learned.
My lord, so for the TC
will
is
give
concerned,
respectively.
yes, respect civil judge senior division number, in fact, the
civil judge,
Civil Judge Senior Division number 2, Kachar Silchar, that is in
Kachar.
respect of the title appeal.
appeal.
And so far the TCR is concerned, that is 37 of 1991, that will be from the court of the
Once we get the district right, there's no problem,
Kachar,
but still,
Kachar,
but
Kachar.
still junior division it must be.
It must
no?
be. Well,
You will, trial TCR, trial record from the civil judge junior division, Kasar. And appellate record from the civil judge senior division, Kasar.
Retaining the copies of the record.
It'll be here.
No, in the trial courts, because
Yes.
original will come here
Yes, yes.
after the disposal.
A scanned copy of the respective original case records may be kept as a backup before the learned courts below. Okay, this is the matter after.
after Bihu vacation sometime, my lord.
You want a date or leave it to the registry? We can leave it to the registry.
Date will be fixed.
Okay, let's the matter after BU holidays on a date to be fixed by registry. Sometimes it's better they leave it. If it does not get listed, you can mention.
Mine. Obliged.
Yeah, did you get that court number? No, no.
I'll just
Not sure. No,
I'll just find it out and I'll convey it right now. I'll do that.
no, we should be correct about the district.
Mine.
That's most important.
I'll do that.
No issue. Okay.
This may come up for order, Miller. It is a long pending case, Miller. It was last listed on 27/8/25.
Wednesday?
Yeah.
Wednesday?
No, on 30th of March,
30.
30.
May I please, Your Lordship? So I beg to mention for listing of a second appeal in the orders column.
When do you want?
Wednesday, Lordship, 25th.
Okay.
Obliged, Lord.
May I please, Your Lordship? Lordship, with the consent of the other side, I beg to mention item number 49 and 50, Lordship. Lordship, madam, item will be listed after 1 week, Lordship.
49 and 50.
Yes, Lordship.
MSc hearings.
Yes, Lordship. Lordship, one humble submission, Lordship, this matter may be, this matter should be listed in the order column, Lordship. There is an I, Lordship.
Okay.
I for condemnation.
Not yet ready for hearing.
Not yet, Lord. Ready.
Nice. Learned counsel, you're for the appellant.
Yes, Lordship.
For the appellant. Submits that with the consent of the other side. It's an adjournment of this matter. And also submits that it has been wrongly listed in the hearing column and should have been listed in the orders column. List the matter accordingly in the orders column on after how
1
many
week,
weeks?
Lordship. 1 week, Lordship.
After a week. On a date to be fixed by registry. Okay.
So, obliged, Lordship.
May please, Your Lordship. Lordship, I beg to mention item number 42, Lordship. But see here in this case inadvertently, Lordship, we have taken the steps only today.
Okay.
So the matter may.
Some more time. Some more time. For the applicant, learned counsel for the applicant submits that steps have been taken today itself, and therefore praise that the matter may be listed again after some time.
Deeply obliged.
How after you've taken steps, no?
Today morning in the.
Okay, so we have to give 3 weeks at least, isn't it? For 4 weeks, after 4 weeks. Of list after 4 weeks on a date to be fixed by registry. Item
Deeply obliged.
42.
42.
It is your lordship. Lordship, I beg to mention item 13 of the daily list today, my lord. So may kindly take up on the next Friday, my lord. That is 27th of March, my lord.
But counsel for the
Appellant, my lord.
appellant seeks an accommodation today and praised for listing the matter next Friday first. List the admission column on 27/3/2026.
Obliged.
Please, Your Lordship. Lordship, with regard to item number 6. Mr. B. Hazarika is having some personal difficulty today, Your Lordship. Kindly matter may be fixed after 2 weeks.
Motion matter.
Motion, Your Lordship.
It's an adjournment due to some personal difficulty. Item 6. List or you said 2 days. No? Can you let it be on Wednesday or Thursday? Wednesday?
Lordship, it will be difficult for him. He's having
After 2 weeks.
2 weeks, Your Lordship.
Oh, I see. I heard 2 days. List after 2 weeks.
Obliged, Your Lordship.
Lordship, I beg to mention a testamentary appeal for listing, Your Lordship. It was filed in February, Your Lordship. May it come up
Not-
anytime next week?
Does not come up. Okay. Next week.
And another MAC appeal, Your Lordship, also
Yeah.
for listing. That was filed,
Single bench.
yes, Your Lordship. Filed last year, Your Lordship, but has not come up.
have
And,
to address these
another
things.
prayer, your lordship, for an FAO, it was last listed on 3rd September. Post that, the respondents have received notice, so it may come up in the orders column, lordship.
Let it be after, you want all of them in the next week only or a little later?
It could be later.
Ah.
The FAO can be later.
My lord, I beg to mention item 22, my lord. This matter has been compromised in between the parties, my lord. So they are supposed to file their compromise proceedings. So let it come up on the after. Bihu, my lord.
Mr. M.H. Rajbarbhia, learned counsel for the applicant/appellant submits that the parties have almost arrived at a settlement in this matter and propose to submit the same before the court on subsequent occasion. And in this context, prays for listing the matter after Bihu vacation. Praise Allah.
My lord, I have another prayer, my lord, item 28.
Just
In
a-
respect item 28.
Just a minute. 22, let me pass the order first. 22. List the matter after the Bihu vacation on a date to be fixed by the registry. Yes, sir. Next one.
Item 28, my lord. This may also kindly be taken off after 2 weeks, my lord.
Mr. Rajbarbhia, learned counsel. 6. Prays for listing the matter after 2 weeks. List after 2 weeks on a date to be fixed by registry. Item 28.
Much obliged, my lord.
May it please your lordship. Your lordship, with regard to our arbitration matter, it's a fresh matter, lordship. On last 2 business, the matter could not be listed and it becomes left over, lordship. Can be listed on Tuesday, lordship, next week. Much obliged.
May I please, your lordship, may I pray for listing of the transfer petition next week, lordship?
Thursday.
Lordship.
At least to your lordship, I beg to mention for listing a CRPI for motion on Monday, lordship.
Let it be on one day we have given, I don't know what will be the list. Let it be on Wednesday.
Some urgency kindly.
Lot of urgency. Okay. Tuesday, Monday or Tuesday?
Monday, lordship. Obliged.
My lord, I have given the number of the Ts.
Maybe item number 1.
May I please, your lordship? The second bill application, my lord. It was rejected earlier, my lord. No, this may go.
So it's fairly submitted that an earlier bail application was rejected on 15/10,
Yes,
right? By this court in AB 2263 of 2025. Investigation must have progressed. Call for updated case diary of Bokajan PS case number 33 of 2025. Okay. It's a POXO matter. So notice has to be issued again. Like yesterday, that issue notice upon the small number 2 in / informant. Office of Public Prosecutor, execute. List after, take the date.
It was applicable, huh? After Bihuti, do they?
No, it's AB, no, so should not be so long. Even if it's like a subsequent, since it's an AB,
Yes.
should not be so long.
Then, my lord,
After 10 days, can you suggest?
my lord,
10 or 15, the maximum 2 weeks. So.
yes. 7, my lord. 7th of April.
Item number 3.
Yes.
Please, your lordship. Lordship, here an ex parte judgment was passed for execution.
Ex parte judgment was passed.
Ex parte judgment was passed, lordship. And in that judgment, the relief for as prayed for recovery of the first position
Mhm.
in the plaintiff was not passed. Although there was a page 24, lordship.
point of determination, Lordship, point two, Lordship, page 24, Lordship. Whether
Yes.
the plaintiff is entitled to relief as prayed for.
Right for.
Lordship, this was put in the point of determination, but the judgment, the order does not reflect the that class position should be recovered. Lordship.
Specific performance was granted.
Yes, Lordship.
Notice at this stage.
This was first export party.
Mm.
Lordship, so LCR maybe call for Lordship. Notice is not required because
But in this case, I think since you have impleaded,
yes,
original LCR, we'll call for the original LCR.
Annexer 3, I have filed a petition for correction of the above order, Lordship.
Mm.
That was
Rejected.
rejected.
Right.
Rejected.
Against that you have come.
Yeah.
Yeah, in that sense, anyway, no harm in showing a notice. Heard your good name, please?
As a sermon.
Yes?
J. Sermon.
As a learned counsel for the revision petition. Who has filed this revision under 227 you filed?
Yeah.
20
115.
27, Article 227 of the Constitution of India, read with section 115 of the CPC, agreed by order dated 2024, whereby passed by the learned Civil Judge Senior Division Jorat, whereby the prayer of the petitioner slash degree holder, you are the degree holder, degree holder for correction of certain parts of the judgment passed in TS number 89 of 22 was rejected. Notice may be issued upon the respondent by taking steps. Call for the original PCR of title suit number 89 of 2022 from the Court of the Learned Civil Judge Senior Division Jorat. That's all at this stage. This is the matter after 3 or 4, at least 3 weeks we have to give. 4 weeks.
If a date may be fixed, I think that's it.
List after 4 weeks on. You can suggest that. Will merge into the holiday otherwise. Let it be on reopening day, 20th April. Okay, 1 month straight. 20th April.
Obliged.
His Lordship. This is a petition under Article 227 of Constitution of India. Petitioner is agreed with the order dated 2/2006, which is at page 42. What happened, Lordship? Different number 6 expired.
Mhm.
Within 90 days, no application for substitution was filed, so it automatically abated. Thereafter, after 3 years, they filed an application under Order 1, Rule 10, read with Order 6, Rule 17, and that was allowed, circumventing the provision of setting aside abatement.
Okay. That has to be.
Yes.
Right. Per se, that has to be set aside.
Yes. There is a delay of 3 years. So they also need to file an application under Section 5 of the Limitation Act. So Lordship, notice may we go by and in the meantime, maybe
Chamber. Yes, sorry. Notice will issue notice.
yes, and in the meantime, suit proceedings may be stayed. Page 42 is the order. I have, and it's a death certificate of the, also, he died on 15/4/2021. And they filed the application under order 1, rule 10, the year 2024. First 2024.
Heard as the request of learned counsel for the revision petitioner who has filed this petition invoking the provisions of Article 227 of the Constitution of India, agreed by order dated 2/2026, passed by the learned Civil Judge Junior Division number 3, Kasar, Silchar, in miss case number 194 of 2024, arising out of title suit number 50 of 2014, whereby the petition being petition number 494 of 2012 filed by the plaintiff under order 1, rule 10, read with order 6, rule 17, CPC, was allowed. It is submitted that due to non-substitution, there was abatement, and without, and after a period of 3 years, without condoning the delay and setting aside the abatement, the petition filed as mentioned above was allowed. The learned counsel also praised for your stay of the proceedings.
Proceedings.
Stay of the proceedings first. Till the next date.
Till the next.
Steps of notice may be taken upon the respondents who are 9 in number.
By speed pool.
I peruse the impugn order annexed as Annexa 7, Roman 7 first, allowing the prayer of the petitioner in this regard. The TS you are seeking to stay of this
Yes.
case. For the proceedings in TS number 50 of 2014 pending before that same court, single suit, junior division. So shall remain state in the next date of listing first. Needless to say that the respondents upon their appearance would be at liberty to seek modification, etc., or vacation of the interim order until the next day.
Steps
List after 4 weeks.
Steps by speed post lawsuit.
Yeah, you can take the speed post.
Obliged.
Should I mention?
I think it is left.
Will be better.
Yes, steps by speed.
Steps shall be taken up by speed post. List after 4 weeks.
Correct.
List
March
after,
of list.
list after 4 weeks. We will give a date. You want a date?
Lawsuit.
We can fix a date also. Be better. 4 weeks. We can take it in the last week of April, maybe.
Lawsuit.
Hmm?
Lawsuit. And
27/4. Okay.
March of list.
Number 5.
May I please, your lordship? Lordship, alleging several procedural irregularities and illegalities in the election of the NF Railway Mazdoor Union, lordship, the petitioners have approached the learned Civil Judge Junior Division. Now, Civil Judge Junior Division was of the view that let the respondents file their written statements both in the title suit and also in the Miss J case, and thereafter the prayer for interim injunction will be considered. Then, lordship, this order I am not taking your lordship to. Then, lordship may directly come to the next order dated 19/1/26, page 288. They have eventually filed their written statements in both the title suit and Miss J case. And ultimately their oral submissions were heard. And in view of the factual metrics of the case and the settled position of law relating to the 3 cardinal principles of prima facie case, balance of convenience, and irreparable loss and injury, this interim injunction was passed. 286, lordship.
Yes.
286. I'm taking your lordship to the operative portion. It starts at para 12, lordship. 11.
286. It starts at 286.
Starts at 286, operative 288. I'm aggrieved by the stay of this order eventually by the senior division, Lordship.
Appellate court.
Appellate court. Now, Lordship, 288. Lordship may kindly see. 288, para 11. I have heard the learned counsel for the petition and also have gone through the record. The Honorable Supreme Court in Dorab Kowaji Warden versus Kumi Sorab Warden has laid down the following guidelines in respect of temporary or interlocutory mandatory injunction. Generally stated, these guidelines are: firstly, the plaintiff has a strong case for trial. That is, it shall be of a higher standard than a prima facie case that is normally required for prohibitory injunction. Secondly, it is necessary to prevent irreparable loss or serious injury, which normally cannot be compensated in terms of money. Next, the balance of convenience is in favor of the one seeking such a relief. Then, Lordship,
Yes.
now these have been considered, and ultimately, Lordship will see page 289. Civil Judge Junior Division has given his findings on prima facie case. Then, Lordship, 291, he has given his findings. 289 itself, he has given his findings below. Below, Lordship, on balance of convenience also he has considered. Then 291, he has considered the third test of irreparable loss and injury also. I'm not burdening your Lordship by going into findings of the Civil Judge Junior Division in all these regards, but Lordship will see para 28.
Para 28.
Para 28.
Yeah, it was allowed.
It was para 27. Under such circumstances, in my considered opinion, if the petitioners were the rightful members who ought to have been elected, they will face irreparable loss and injury, which cannot be compensated in terms of money. So such findings are there in respect of each of the tests. Then, Lordship, accordingly,
The dispute was about election
dispute was about
in the
election.
organization.
In the organization, several procedural irregularities. I am not going into those Lordship, because the court below, the trial court below, has also come to the findings regarding prima facie case. For a moment, Lordship will see prima facie case, page 289. In the instant case, the main dispute is as to whether the election is held in the 66 AGM 14 BGM in the NFL Mazdoor Union was fair or not. It is to be determined as to whether the election process was conducted in a proper manner without prejudice to anyone. From the pleadings of both the sides, it transfers that the above dispute has to be determined in the main suit after the consideration of the evidence, and as such, I find that there is a prima facie case to go for trial. Then, regarding balance of convenience also, election was held and tenure of the body was for a period of 2 years. And by now, Lordship, already 10 months are over. Now, if an illegally constituted body, illegally elected
happening
body,
in many election type cases, the period gets over.
yes, then
Anyway.
it will become infructuous. So, balance
No,
of
but the thing is that,
then now Lordship will come to the impugned.
the people who are the persons, the opposite parties who have been restrained, they have been elected. They have been elected.
They were elected. In my, I have alleged wrongly that they have been elected wrongly.
Wrongly, but that is a subject of determination, right? On the
Subject
basis
of
of evidence. Evidence, obviously.
But prima
anyway-
facie also, to your Lordship satisfaction, I can show.
So in the appellate court, state
Appellate-
that order.
Appellate court Lordship will see the order.
The appeal is pending, still pending, but they've stayed the order.
316 order. Impugn order is at page 328. Civil Judge Senior Division has stayed the order merely on the ground that a misappeal has been preferred. All these tests of granting interim injunction facts have not at all been considered. And most importantly, I had even filed one caveat, Lordship. I was not even heard. This was an ex parte order. Page 328, Lordship will see the impugn order. 328, operative para 8. Operative para 8.
That is in page 329.
329. Considering the grounds as set forth in the memorandum of appeal and the materials on record, the instant appeal is admitted for hearing. However, since the present misappeal arising out of the impugn order dated 19/1/26 passed in NIJ case number 187/25 arising of title suit so and so, so until and unless the appeal is decided, if the order passed by the learned trial court is in existence, the very purpose of the appeal will become infructuous. Accordingly, for the ends of justice impugned, order passed in Miss J case, number so and so, is hereby stayed. Lordship, it appears that the order has been passed by default, automatic, as if
No,
any
but
person.
yeah, but you can also, you could have also gone to the appellate court to seek, modification, negation of the stay order, isn't it?
But
That option was there. But anyway, you exercising this jurisdiction,
Yes,
which is
there-
also open to you.
Yes, there was a caveat also. I had also filed one caveat.
Caveat,
Caveat at 294.
caveat should be discharged anyway.
I was not given a copy of this petition, misappeal, and I was not even heard. And this was an ex parte order. And the Lordship will kindly appreciate the grounds. Ground is only that since they have preferred a misappeal. Whereas in the case of junior division, Lordship, it was a detailed order after hearing both the parties on contest, written submission, oral submission, judgment of the Honorable Supreme Court regarding the three cardinal principles. Now, in my humble submission, this is not even a speaking order, Lordship. Only ground, as I've already submitted, they have preferred appeal. So in that, under such circumstances, going by that logic, Lordship, in every other case, it has to be stayed, Lordship. If going by that logic. Now, if your Lordship will kindly appreciate, if I may kindly appreciate one of the procedural irregularity, Lordship. One, just to place that there was a prima facie case. I will not go into other details. There are several procedural irregularities and illegalities.
As you know, the standards of, the standard of the injunction in organizational matters is slightly higher, isn't it? In organizational, these kind of matters, elections and how organizations are to be run, it is slightly higher, the standard of granting injunction. Whatever little I know.
But the
So anyway,
interim injunction was
let me
granted.
see, whatever it is, it was granted and you are agreed because it is vacated. That's okay. That's understandable.
Now, if I may show,
Yes.
Lordship,
Which part, which
only,
page?
only one of the procedural irregularity.
Yes.
Lordship will see page 135. 135.
Okay.
Uh,
Wait.
sorry, Lordship, page 80. Page 80. Page 80. By this order, by this letter,
Just a minute, come to page 80. Under the heading,
yes,
this one?
scrutiny regarding scrutiny committee, under the heading NF Railway Mazdoor Union. It is in their letterpad dated 19/3/25. It was communicated to all that I am reading this body of the letter, Lordship.
Yes.
As per decision of the last working committee meeting held at Pandu so and so, a meeting in connection with the nomination of scrutiny committee member was held at Pandu on 17/3/25 with the president and the general secretary joint. Accordingly, a scrutiny committee with 5 members nominated by 5 joint general secretaries have been constituted to conduct the election in BGM. Now, the competent authority to conduct the election, this is issued by the General Secretary of the NF Railway Mazdoor Union. This is not disputed at any stage, Lordship. So the competent authority to conduct the election is the scrutiny committee. Now, scrutiny committee will publish the list of voter list. It will take nominations. It will cancel nominations if necessary. It will conduct election, declare result, and communicate the result to the railway administration for circulation. Now, Lordship will see who has conducted the election. Who has conducted the election? There is an observer. Now, NF Railway Mazdoor Union is an independent union registered under the Trade Unions Act, and it is a sovereign independent body.
It will depend on the rules, what the rules say.
Constitution I have enclosed. Constitution I have enclosed. There is no mention of even an observer. There is no mention of an observer. Now, what happens? An observer comes from nowhere, Lordship. An observer comes, he is not even a member of the organization. That your Lordship will see at page 165. Observer prepares a list. 165, Lordship will see.
Okay. 165. SK Tyagi.
Lordship will see you for a moment. 169, Lordship. 169. I'm sorry, Lordship. 169. 169. This is the ultimate result. This is the ultimate result This is the
election result.
This is the ultimate result circulated by the railway administration. Ultimate result against which I am aggrieved. 23/4/2025. And reference lordship will see.
Okay, let us see this order.
Yes,
Let's have a
I'm
look.
reading this publication of list of central office bearers of NFR-MU. Reference assistant GS letter dated 17/4/25. Assistant GS of AIRF. AIRF is a separate body. This is not our body. All India Railwaymen Federation. It is a separate body, not the NF Railway Mazdoor Union. And assistant GS, this is the observer. Now, I am reading this order. The list of newly elected central office bearers of NF Railway Mazdoor Union is forwarded herewith for information and general and guidance, please. The central office bearers were elected by 14th biennial and 66th annual general meeting of NFR-MU held on so-and-so. Transfer orders of newly elected officials after the election should be dealt with in terms of extant instructions, rules on the subject. The list is published provisionally subject to verification of following points by the concerned division. Then below it is not relevant. Now I am aggrieved by this order. But most important thing, Lordship will see reference. Reference, the railway administration has circulated the list on the basis of assistant GS ARF's letter dated 17/4/25. That letter is at page 167. Now, is he competent to communicate the railway administration the result of the election? Page 167. That is the question, Lordship. Page 167.
Communication or conduct of the election is in question.
He has conducted the election, declared the result, and communicated the result to the railway administration.
Assistant General Secretary has conducted the election also.
Yes, and he is not the General Secretary of NFR-MU. He is General Secretary of some other railway organization union. Page 167, Lordship will see.
I'm on 167.
Yes. It has been communicated by SK Tyagi, Assistant General Secretary of AIRF, to the General Manager of NF Railway.
Let us read the body of this letter.
Yes.
Undersigned.
The undersigned was nominated as AIRF observer for 14 biennial and 66 annual general meeting of NFR-MU, which was held on so-and-so, by GS AIRF's letter dated so-and-so. The said meeting as well as the entire election process of the central office bearers of NFR-MU were witnessed by the undersigned till counting of the votes, which was completed in the afternoon of so-and-so. Based on the results of the votes obtained by the contestants, the final list of elected central office bearers of NFR-MU is being attached herewith. It is therefore requested that the attached list of elected central office bearers of NFR-MU be circulated to all concerned. Now, this has been done by this particular person. But till today, scrutiny committee is absolutely silent. We have made representations also. It is silent. It has not declared the result. It has not communicated the result to the railway administration for circulation. I have applied one RTI. I have procured some information through RTI reply. And what does it say, Lordship? Page 331. Who is to communicate the
Page
331. RTI reply.
Okay.
Para 2, Lordship will see.
RTI reply.
Para 2. My question is at left side. What is the prevailing custom in the GMP MLG's office to publish the list of central office bearers of NFR-MU of NF Railway?
Right.
What is the practice since all these years?
The reply is,
Yes. Who communicates and how it is circulated? Please mention the authority whose letter has been the basis of the publication of list of central office bearers during the last 5 occasions and whose letter has been quoted as reference in the letter of GMP-MLG while publishing the list of central office bearers of NFR-MU in the last 5 occasions. Please arrange to provide the list published in the subject matter in the last 5 occasions. Now, answer response is on the right side, second column, third row. The letter from GS-MU, Mazdoor Union. GS-MU is NF Railway, has been taken as basis of publication of central office bearers with approval of competent authority. The last 5 publication of central office bearers of NFR-MU is enclosed as annexure 6 to 10. And last 5 occasions, Lordship will see page 334 to 339. This is the result of the last 5 elections. Communication. made by the General Secretary of the Mazdoor Union. Page 334 letter dated 13/2/2014. This has been communicated by the General Secretary of the NF Railway Mazdoor Union to the General Manager. Now next page, Lordship will see, this is also of 2016. Communicated by General Secretary NF Railway Mazdoor Union to the General Manager. Then next also next also same thing, Lordship. All 5 elections, it has been communicated by the General Secretary of the Mazdoor Union to the Railway Administration for circulation. So it is the generals, because it is an independent sovereign body, they will themselves communicate their result to the Railway Administration. And a third person, he has no locus standi to interfere and declare the result and communicate it to the Railway Administration. But here in this case, this has been done. So this is the most pivotal, Lordship, illegality, which I am trying to show.
The communication.
Not only communication, he has conducted the election.
The main thing is the conduct. Anyway,
Yes.
so this is basically.
Not only conducted, and he has admitted in his reply before the court below, he has admitted that he has conducted the election. And he is also a party. And so this is the most pivotal. Just in order to show that there is a prima facie case for trials, I have appraised this illegality. Now, besides this, there are several other illegalities, Lordship. So considering all these things, Lordship, the Learned Civil Judge Junior Division has granted the temporary injunction. And it was a fair order granted on the basis of considering facts, legal position on grant of injunction, and after hearing both the parties on, and it is an order of on contest and on merit. And the decision of the Civil Judge Senior Division, that is not even a speaking order, Lordship. Not even a speaking order, I was not even heard, Lordship.
That was a kind of preliminary order. Anyways, so
I had been able to appraise before the court below that I at least I have a prima facie case, and Lordship, it will cause irreparable loss and damage, and that is sufficient for grant of an interim order, Lordship. I shall rebut if necessary, Lord.
yes, I'll go. You have filed caveat, right? There are 27 respondents, right?
My lord.
And remaining are 28 to 36 are pro forma respondents. You are appearing for, Mr. Majumdar, you are appearing for
I'm appealing for the respondents, my lord.
all respondents.
Respondents who have been elected.
Okay, no, they are all 20, all 27,
My lord. Yes.
all the 27 respondents. It's okay then. And pro forma respondents, anybody from?
Pro forma.
No,
May I
28
clarify?
to 36.
Pro forma respondents were there in the earlier list also and in the new list also.
So the respondents are represented already.
My lord, respondents.
Okay.
May I please, Lordship? At the outset, I'll respond to the submission of my learned friend that there was a caveat and they were not heard before the
Okay.
lower appellate court below. My lord. Lordship, may I kindly turn to page 294, my lord. That's a very serious allegation, my lord. If there is a caveat and without hearing the caveat, normally order should not be passed. And if any order is passed, that amounts to a nullity, my lord. So I have to respond to that. Page 294 is the caveat filed by them before the Learned Civil Judge Senior Division, number 1, Kamrup. Page 294, my lord. The next page, the caveators are 3 in number who are the plaintiffs ultimately.
Mhm.
And Lordship, may kindly have a look at page 295, the prospective appellant.
Mhm.
Prospective appellant is Rupjyoti Kalita.
Mhm.
He is not a party in the suit. If an order has been obtained by the plaintiffs against the defendants or the pro forma defendants, it is expected that one of the defendants who are aggrieved by that order, they will file an appeal.
Yes.
Now, they somehow chose not to mention names of any of the defendants against whom the
Who are beneficiaries of
Yes.
that order.
my instruction is they do not even know who is Robjit Kalita.
He's a stranger according to
A
you.
stranger. Now you file a caveat against a stranger and you make an allegation that they were not heard. Who is Robjyoti Kalita? He's not a party. Let my learned friend show that he is one of the defendants. Even now, my learned friend can show if he is so confident about it.
May I interrupt, Lordship? I should have placed it beforehand only. I missed it out, Lordship. I fairly admit that, Lordship, there was a defect on the part of the petitioners in drafting the caveat.
He should have
So-
pointed out my at the.
So,
all right.
I should
He should have pointed out that there was a defect.
pressing on this, Lordship.
Yeah.
He is a submission. That is why I am responding. Otherwise, I would not have responded.
I'm not pressing on this, Lordship.
But don't say that there was a caveat and you were not heard. And I appeared before the learned court below, before the appellate court, and I argued for 1.5 hours to convince the court that the temporary injunction order passed by the learned trial court was absolutely arbitrary, unreasonable, for the simple reason, and I'll show from the order, the facts to some extent have been recorded by the learned trial court, but at the end of the order, the order was passed simply on the ground that the tenure of the union is 2 years. Now, meanwhile, about 8 months have passed. Page 2. Lordship, may kindly turn to page 286 for a moment.
As I said, that is the
That is the
challenge
only
in many election related matters.
Yes,
But that's 280.
286 Lordship, may kindly have a look. The important manner.
Yes.
The relevant portion is at 291. 291 under the heading irreparable loss and injury, the my lord, finding of the learned court below is, trial court rather. Now the tenure of the newly appointed body is 2 years and already about 8 months have passed till now. Under such circumstances, if the newly appointed body is allowed to function, the main suit itself may become infructuous and the whole purpose of filing the suit might be defeated. My lord, is that a ground to be taken into consideration for the purpose of granting a temporary injunction? And otherwise, my lord, learned trial court is aware that the court has to record a finding that there is a prima facie case. And for that, Lordship, may kindly have a look at page 289. How the
Yes.
learned court below has observed about the prima facie case. Page 289, para 16, my lord. In the instant case, the main dispute is as to whether the election held in 66 AGM and 14 BGM of the NF Railway Mazduri was fair or not. It is to be determined as to whether election process was conducted in a proper manner without prejudice to anyone. This is nothing to do about the facts of the present case, my lord. This is general observation. Now, para 17. From the pleadings of the both of sides, it transpires that the above dispute has to be determined in main suit after a consideration of the evidence, and as such, I find there is prima facie case. And is this the way a prima facie case is recorded, my lord? Nothing, no discussion. Court, my lord, Supreme Court has made it very clear. Prima facie case is a matter which means that at the end of the trial, there is a likelihood that if the averment made in the plaintiff is accepted to be correct on its face value, a suit is likely to be decreed. I'll show more one judgment of the Honorable Supreme Court
A
which says that.
tribal issue and something on those lines.
Yes, ma'am. Now, secondly, balance of convenience. Balance of convenience, my lord, next. It
It's
says,
related to that actually.
yes. However, para 20, my lord. However, prima facie from the documents submitted by the petitioner side, primarily first page of the ballot paper compendium of results dated 6/4/25. It appears that there is note about the objection raised about the irregularities of the election on it. Absolutely vague. What is this note? How does it affect the election? Whether the election has been rendered illegal or unacceptable because of the note? No discussion. There is a note, so I find there is the irreparable loss. A balance of convenience is in favor of the plaintiff. Now, lastly, my lord, I have shown, my lord, from page 291. So far as irreparable loss and injury is concerned, the only concern of the court is that 8 months have elapsed already and the whole tenure of the union is 2 years. So the
suit will become infructuous. My lord, indirectly the court is saying that I have not been able to dispose of the suit early, so let them have one side have an injunction to the prejudice of the other side. That cannot be the law, my lord. Now, my lord, what has happened in this case? I'm just in gist. I'm giving your lordship. My lord, in the last election was held in July 2022. These are all admitted position. I'm arguing from the admitted position. Last election was held in July 2022, and admittedly under the constitution, the tenure is 2 years. That tenure of 2 years have, my lord, elapsed in the month of July 2024. After that, the former general secretary and all, maybe because new election is not held, they are continuing. And I show from the averment made in the present revision petition before lordship that their case is that if because of the irregularities we have pointed out, we are allowed to continue, other side would not be prejudiced. As if a fairly or duly election held can be, my lord, rejected only on the ground that if we are allowed to continue during the pendency of the suit, no prejudice will be caused. This is what they are saying. There's a clear averment in the revision petition itself. I'll come to that a little later, my lord.
Okay.
Let me point out what has happened in this case. So July 24, the term has expired. Now after that, they are continuing. Now, before this election came out, so far as their constitution is concerned, the appellant has annexed the constitution. Constitution is absolutely silent about how the election will be held.
Okay, it's silent.
Absolutely silent. Now, in all earlier elections, my lord,
That's a gray area kind of.
gray area.
Anyway,
Now,
so
my lord,
can be rectified.
fortunately, this time, my lord, all the members of the existing union decided that we'll invite someone from the Central Federation to oversee the matter.
Okay.
And that letter your lordship will find at page 163, my lord. There is a reason why I'm showing this. The presence of observer is because of them, not because of us.
163.
163. Is the letter written by the former general secretary who is writing all the representations that the election should be rejected and there should be fair election.
General Secretary at the All India level.
No, he's the general secretary at the local level, my lord, union.
No, the page 163.
163 is not Frontier Railway Mazdoor Union, Gauhati, my lord, Gauhati Center.
No, Shiv Gopal Mishra.
He has written to the, your lordship is correct, my lord, to the Central All India Railwaymen's Federation. He says that 14th biennial and 66th general meeting of NF Railway Mazdoor Union will be held at Maligaon from so-and-so to so-and-so April 2025. You are requested to attend the above meetings and also grace the open session of the conference at so-and-so on 3/4/2025. They have invited. Not we, my lord. Ashish Biswas, General Secretary, is the main man behind the entire present litigation, my lord. He is one of the main men. Now, he has written to the Central Federation that kindly be present there to grace the occasion. Now, this led to the document, my lord, your lordship will find. Next page, 164. Gopal Mishra has responded saying that he will not be able to come here because he will go to Czech Republic for attending a meeting. He says, my lord, this letter I'm reading.
Yes.
As during the period I will be attending a meeting of Railway Workers Selection Steering Committee slated to be held from 3rd to 4th April 25 in Prague, Czech Republic. It will not be possible for me to join you all on this occasion. However, I have deputed Sri S.K. Tyagi, Eastern General Secretary, AIRF, to attend the aforesaid meeting of North Frontier Railway Mazdoor Union on my behalf. Sri S.K. Tyagi will be an observer of on this occasion. This is how the observer came into the picture. Now they are alleging who is observer. You have invited the observer. At your instance, the observer has come and he was present during the election and the meeting.
Mr. Ashish Biswas. He's one of the plaintiffs.
He's not a plaintiff. He has not joined.
The respondent.
He's a respondent.
I'll show my lord, he has written all the representations after the elections were over.
So he was invited, he could not come, and Assistant General Secretary was deputed.
Deputed as an observer. Now, Lordship will kindly say, so for this election, my lord, scrutiny committee was appointed, which your Lordship will find at page 80.
You've shown me. Page?
Page 80, my lord.
80.
Right. My lord, this Lordship is got, my lord.
Yes.
My lord, the same gentleman, Ashish Biswas, General Secretary, he writes to the Central Office Bearer, all division of conveners, all branch secretaries, NF Railway Mazdoor Union, regarding scrutiny committee and conducting of election in connection with 14th biennial and 66th annual general meeting of NF Railway Mazdoor Union to be held from so and so and so. As per discussion of the last working meeting held on so and so, a meeting in connection with the nomination of scrutiny committee members was held at Central Office Pandu and so and so with the President, General Secretary, 5 joint General Secretaries. Accordingly, a scrutiny committee with 5 members nominated by 5 joint General Secretaries has been constituted to conduct the election in this year. So it is under the supervision of this scrutiny committee that the election is to be held. Now the election was held.
The scrutiny committee was involved in the election?
Exactly, my lord. Now, if your lordship kindly goes to the plain Abatement, what was their case? They have made some improvement before this on the court because obtaining some document. I'll come to that a little later, my lord. Lordship may kindly have a look at the plaint. What is the case they have projected before the learned trial court? Plaint is available at page 35, my lord.
Okay.
I'll take your lordship straightway to, and before that, lordship kindly allow me to show that at page 35, the name of 3 plaintiffs.
Yes. Dhiraj Chaudhary, Uttam Bhattacharya,
My
Rakib Bhojam.
What has happened is, your lordship is aware, in election matters, if a person is affected because of the discrepancy in the number of votes cast and the number of votes actually found at the time of counting, etc. This is the allegation here. It is an individual grievance. He must file an election petition or maybe a suit challenging the election against the person who has been elected. Here, what they have done, after the election, all these 3 persons who were the former office bearers of the committee, so far as plaintiff number 1 is concerned,
former office bearers who
they have contested
after the lapse, they were continuing.
Yes, continuing. They are continuing. They have got an interest to continue further, my lord. So now, so far as plaintiff number 1 is concerned, who is petitioner number 1, he was a former vice president of the general body. He has contested for the post of vice president and lost by 1 vote only. This is relevant, my lord, why they want to continue. It is very difficult to accept a result of an election where you lose by 1 vote only. And there are a number of litigations even in the assembly and MP, my lord, where by a short margin, someone wins, he contests the elections, and there are reported judgments. I can show you, lordship, where after the recount, the difference becomes even more. Whole cases filed on the ground that there was wrong, there was error in counting, and after the recount is allowed, recount is held, it is found the difference is more. Anyway, my lord, so far as plaintiff number 2, petitioner number 2 is concerned, he was the former joint general secretary. He is the main person behind the whole litigation here, my lord. He has lost the election by a margin of 8 votes. That is very relevant, my lord. The only ground they have taken in the present suit is that there is a difference between the number of votes cast and the number of ballot papers found in the counting. They have pleaded, my lord.
Meaning thereby that they are indicating that more extra ballots were.
See, my lord, there is they themselves have admitted that there was difference of 3. And he lost, number 2 lost by a margin of 8 votes. 8 votes. Even if we deduct 3 from the winning candidate and add these 3 to him, even then he doesn't win. And therefore, my lord, although they have shown the discrepancy of 3 votes, in the suit their pair is not recount. Their prayer is to have recall, meaning thereby that give me one more chance, I'll do further campaigning because campaigning was not proper. So I get another chance to get elected. Now, so far as number 3 is concerned, my lord, he was earlier a central organizing secretary, one of the 9 central organizing secretaries, and he was elected, my lord, in spite of the he has come. He has been elected. He has got no grievance. He joins because he is in the same camp, my lord. Now, if your lordship will find.
No, but he has been, if he's assailing the process, this my preliminary observation.
No,
Don't take it beyond
your
that.
lordship is right.
That if he has got elected by the same process, can he turn around and say that these two may have
They may have a grievance.
anyway? We'll see. That's
And
preliminary.
their allegation your lordship will find
I may
in
be
page
wrong.
46. Page 46 of this revision petition, my lord. I have already indicated, but I'll once more show what is their allegation in the complaint. In order to support my submission that this suit at the final trial, my lord, is not going to be decreed. Page 6 at page 46, my lord, para 6. I'll be brief, my lord. I'll try to be brief.
No issues.
Para 6, that the election was conducted on 5/4/2025 and counting was to go on till 6/4/25. I am reading my lord, para 6 at page 46. However, strangely and against normal convention, no polling counting agent of any candidates was permitted to be present at the time of counting of ballots so as to observe the process and raise objection on behalf of the candidate at the earliest possible opportunity where, and if so warranted, in fact, only the agent of one of the candidates for the post of General Secretary was allowed to be present, which is clear instance of discrimination and favoritism on the part of the scrutiny committee. Certain other irregularities were noted herein, wherein candidates were contesting for only one post, but ballot papers showed them to be contesting in respect of another post as well. And some of these errors in the ballot papers were corrected on the spot by striking out through pen or hand itself. This has given rise to the clear possibility that some ballot papers may to even been corrected, struck out, and non-contesting candidates have been incorrectly shown in the respect of some posts, leading to splitting of votes. This is evident in the case of, say, Deepak Kumar Sarkar, who had only contested for one of the vice president, but his name was also erroneously reflected in the ballot paper for the post of General Secretary. Now, this is important, my lord. That the crisis, this is the main issue, my lord. The crisis boiled over when it was seen that for the post of General Secretary, number of votes polled was 606 as per announcement of the scrutiny committee, while the number of scrutiny committee is involved in the election. While the number of ballot papers counted in total was 609. Thus, there were more ballot papers found than were actually casting votes in the field. This was informed to the plaintiff number 2, who was one of the contesting candidates for the said post, and he immediately sent a letter to the members of the scrutiny committee on 6/4/2025. This issue demanding stoppage of counting process and holding of fresh election, Lord will kindly see. If you have this kind of allegation, kindly ask for recount, not fresh election. The results were tabulated by the scrutiny committee. Again, scrutiny committee has done the thing. And as yet, unknown person proceeded to write up by hand the number of votes cast for each contending candidate for each post. The final tally of votes was thus merely noted down on the ballot paper itself without any clarity as to the number of votes cast, the number of ballots found, invalid, the signature, identity, etc., etc. This is the only allegation.
Yeah.
Well, page 14 at 52, let me just have a look. Thereafter, I'll make my submission. Page 14 at page 52, my lord. Para 14 at page 52.
Yes.
This is the further allegation in the plaint, my lord. Plaintiffs beg to state that the respondent number 36 was the deputed to act as an observer, which is reporting or facilitatory role at best. However, the same defendant suddenly decided to act as a returning officer at large, announced the results of election that was heavily disputed, controversial, and even disparaged by him as an observer at the time of conduct thereof. Thus, there is ample evidence for presumption as to clear violation of ethical and procedural norms of conduct of an election as envisaged by the Constitution and other laws of the land, including the constitutional rules holding the field. The observer had also signed over the list of central office bearers, and thus lending an imprimatur of legitimacy to an election he had himself stated to be irregular. These are the allegations, my lord. Now, my lord, lordship will kindly see, allegations are made that scrutiny committee, who was the authority to conduct the election, did not do their job. They allowed the observer to take over and act as a returning officer, and that led to an illegality in the election. My lord, I'll show from both the parties, my lord, all these persons whom I'm representing before your lordship did file their written statement. The observer also independently filed a written statement. Now he is a my lord, neutral person.
In the suit.
Yes. My lord, lordship, may I kindly have a look at the written statement filed by the observer. 194, my lord. What has actually happened in the elections that your lordship will see from here.
194.
194. I'll just read two paragraphs, my lord. Page 201.
Yes.
The para 26, my lord, that the present defendant number 36 further submits their voting of election held in so-and-so started on 6/5/4/2025 and the same was completed on the same day. Lordship has got, my lord.
Para?
Para 26 at page 201.
Yeah.
Para 26. That the present defendant number 36 further submits their voting of election held in said 66th AGM and 14 BGM of NF Railway Mazdoor Union started on 5/4/25 and the same was completed on the same day. The total number of votes in the voter list were 629, out of which 609 votes cast their votes. In the said election, 606 votes were polled, but on counting, 609 ballot papers were found in the ballot box. Thereafter, ballot papers were recounted. Lordship will kindly see. There were 3 rounds of counting ballot. First time it was counted, then recount, then again recount at their instance, and they are silent about it. It says, my lord, I'm continuing. In the said election, thereafter, ballot papers were recounted at the supervision of the present defendant number 36 as observer, and during such recount, it was found that 3 ballot papers bearing serial numbers so-and-so, so-and-so, and so-and-so had been accidentally issued twice. After the verification, Piyush Chakrabarti got 299 votes and Uttam Bhattacharjee got 291 votes. Uttam Bhattacharjee is the plaintiff number 2. Plaintiff number 2.
8 votes less.
8 votes less. This is what they have pleaded, that plaintiff number 2 got 8 votes less than the winning candidate. Now next para, my lord. That present defendant number 36 states that he as an observer found that in spite of repetition of serial numbers, the said ballot papers were in appropriate order. At the time of counting of votes, a total of 19 votes were found invalid as per the decision of the scrutiny committee, and accordingly, a total of 590 votes were declared as validly cast. General Secretary, namely so-and-so, scored 299 valid votes, and on the other hand, the other contesting candidate, Bhattacharjee, secured 291 valid votes. The present
that means just sorry for interrupting. Because 3 ballots were found extra,
yes.
But they were found to be in order according to him. Yes. But the serial number repeated. So they were not deleted; they were included.
Yes.
Okay, please proceed.
Para 29 says, present defendant number 36 submits that he as an observer was present right from the start till the process of conclusion of the counting of votes. The present defendant number 36 as an observer of the election held in so-and-so, verified and counted the actual votes obtained by contesting candidates. Thereafter, present defendant prepared the list of successful candidates of the said election and forwarded the said list along with letter dated so-and-so to the General Secretary, New Delhi. It is apposite to mention herein that some defeated candidates, and this is important, some defeated candidates of the said election created a chaotic situation after the counting of votes. Due to such chaotic situation, the observer observed that the result cannot be declared at that moment with a view to stop any untoward incidents on that day. Since the election was duly conducted, the present defendant number 36 declared the result of the election subsequently. The present defendant number 36 submits that he issued a letter dated 17/4/25 to the General Manager, Personnel, Maligaon, declaring 35 candidates have been elected. So suspense. So he has stated the true state of affair, what has happened. Now, if your lordship kindly turns to the result sheet once, which your lordship will find at page 90.
This
This is the
tag
main
is
result sheet, my lord.
important.
Yeah, yes, my lord.
Okay.
My lord, it is handwritten on top. Below mentioned candidates have obtained, it should be obtained votes, my lord, during the election conducted on 4/4/25 at Maligaon. Now, left hand side, there is a, my lord, endorsement. I being candidate of the post of GS post, that is plaintiff number 2, my lord, not agreed to above result owing to gross irregularities. He is unable to show any other irregularity except for the vague expression that gross irregularities. Kindly show if there is a discrepancy of 3 votes, assuming for the time being, although there is no specific allegation as such, that 3 votes which were extra or maybe irregular has been counted in favor of the winning candidate. That is also not his allegation. So what is the purpose of filing this suit? It is the purpose is to have a fresh election, so that we can make one more attempt. Now, at the bottom also, my lord, sorry, in the middle also, kindly what is the observation of the observer? Since one of the candidate for the post of General Secretary has raised objection, as such, the results cannot be declared Mr. Tyagi. And then at the bottom also, again, I have objection on the result declared because of gross irregularity. They are using the expression gross irregularity, but they are not going to any specific allegation, because allegation is simple, that only 3 votes, there is a discrepancy of 3 votes between the votes cast and the ballot papers found in the counting. Thereafter, 2 rounds of recount took place. In both the recount panel, all of them have lost by a particular plaintiff number 1 and 2. And thereafter, this suit. Now, your allegation is that observer has taken over and scrutiny committee did not do their duty. Scrutiny committee has not been given the opportunity to respond to this allegation because they are not a party. Neither the committee is a party nor its members. Observer is a party who is a neutral man. Observer has observed in the written statement also that everything was fair. And in the result sheet, it says that one person has raised objection with the allegation that there were gross irregularities. And thereafter, he says in the written statement, because in order to prevent any untoward incident, for the time being, he stopped it. This is the whole case. Now, my lord, the question is, when this suit is pending, yes, at the end of the trial, the court will, trial court on the basis of evidence will decide what is to be done with the result. The question is before the trial court, my lord, whether there is any prima facie case and whether the balance of convenience and other 2 ingredients are in favor of the plaintiff. Now, I'll show one judgment where the Honorable Supreme Court says, I'll just show the judgment here.
Before we proceed, let me ask you one thing. Since you are representing, you all have all the copies and you're representing all the respondents, are we disposing of? It not be. What about the
I'm
this petition?
So far as
The pro forma response.
So far as this revision is concerned, here they have come against the interim order of stay passed by the learned first appellate court. Appeal is still pending. Appeal is to be heard. My suggestion before lordship will be, lordship may not interfere with the order, but direct the learned appellate court below to dispose of the appeal within a short time, maybe 7 days, 10. I'm ready, my lord. This is one.
Everyone has the docket load. But anyway, we can always make an
because my lord, here when they have come against only the interim order of stay. If your lordship somehow interferes with the order, with that order, appeal will remain pending. They will start functioning. They have not been elected. That is why I'm saying, my lord, lordship will have to decide whether the learned trial court was right in granting a temporary injunction whereby the elected members were restrained and persons who lost the election will be allowed to function, because Lordship may kindly have a look at the revision petition.
So that's why I'm saying, disposing of this matter, that is your suggestion,
Yes.
right?
My-
With that kind of direction.
Yes.
Because
My lord-
both of you have argued at length, that's why I asked this question.
Page 24, Lordship may kindly see.
It'll take some time otherwise.
Just one thing I'll show, my lord.
Yes, yes.
Page 24.
Pro forma respondents
No, they are not going to contest also.
prejudice. to-
No,
Page 20.
page 24, para 13. Page 24, para 13, my lord. My lord, line about 4 from bottom. Lordship has seen, my lord. Inconvenience would be caused to anybody as under such circumstance, the previous list of elected office bearers under letter dated 21/7/2022. That means that in the election that was held in 22, they were elected, shall undertake the duties and responsibilities of the union. So what they want is, the purpose is that we should continue. Election has been held, we have lost, we have filed a suit. Now by virtue of an injunction, we should continue. And if the suit continues for more than 2 years, then the suit itself will become infructuous. And even if they have lost the election, they will succeed in continuing as the members of the office of the union. That is the case. Now, my lord, only one legal submission I will make with your lordship. In a case of this nature, what the learned trial court ought to have decided is, Supreme Court says there is a risk of granting injunction, because at the end of the trial, if an injunction is granted and the suit is dismissed, then the party who has ultimately won in the election has been deprived. Now there is a risk of being wrong. Similarly, my lord, today injunction is not granted and we are allowed to continue. Then at the end of the suit is decreed. And they have been deprived in the meantime. So there is also a risk of being wrong on the part of the court. But which one is more?
Balance of convenience.
Because, my lord, if the suit is decreed, they are not going to be directly declared elected, but only a fresh election will be held, and in which they are likely to win and also likely to lose the election.
Well, that is another matter. but-
Another matter. So it's not a case where, based on the, it's another submission I'm making.
No,
Based on
sometimes
the,
in election matters, I mean, if it is proved by the evidence that this is B should be the winner, then it can be declared. But the thing is that otherwise, if that kind of clarity on the basis of evidence is not reached, then at best fresh selection has to be done.
fresh election, but that's what I'm saying. In the fresh election, you only get an opportunity of contesting the
Yes,
election,
certainly.
not being declared elected straightway, because you have to win the election. And if you are
fresh selection is
yes,
that.
so in that case, my lord, my submission will be, if the injunction is refused to the plaintiff, there will be less prejudice than the situation where if injunction is granted and elected members are restrained from functioning, and if the suit is ultimately dismissed. And may I show that judgment, my lord, if your lordship? This is 2025.
You're submitting. Yeah, you've given this. Sheikh Dada Mia something.
Yes.
AP from Andhra Pradesh.
This is from Andhra Pradesh High Court. I'll be relying on the Supreme Court judgment rather, my lord, on which reliance was paid. Personally, kindly have a look at this. 2023 SCC online, Supreme Court, page 177. It's a huge judgment from South India, my lord, related to one election only. It's an election matter. Para 73, my lord. I have not taken the printout of the entire judgment.
It's okay, no problem.
Oh, I am sorry, my entire judgment has been given to your lordship. Lordship may straightway turn to para 73. I'm sorry, my could not play.
Para 7.
Para 73, man.
Yes, yes.
Apart from the above, we may also take note of the principles in relation to the matters concerning grant of interim relief, which have been stated and re-emphasized by this court. In the case of Union of India, versus Raj Grow Impacts LLP 2021 Supreme Court SCC Online SC 429 as follows. In addition to general principles for exercise of discretion as discussed here and above, a few features specific to the matters of interim relief need special mention. It is rather elementary that in matters of grant of interim relief, satisfaction of the court only about existence of prima facie case in favor of the suitor is not enough. The other elements, namely balance of convenience and likelihood of irreparable injury, are not of empty formality and carry their own relevance. And while exercising its discretion in the matter of interim relief and adopting a particular course, the court needs to weigh the risk of injustice if ultimately the decision of the main matter runs counter to the course being adopted at the time of granting or refusing the interim relief. We may usefully refer to the relevant principles stated in so and so, All England Reporter. The principal dilemma about grant of interlocutory injunctions, whether prohibitory or mandatory, is that there is by definition a risk that the court may make the wrong decision in the sense of granting an injunction to a party who fails to establish his right at the trial or would fail if there was a trial, or alternatively in failing to grant an injunction to a party who succeeds or would succeed at the trial. This is what I was saying, madam. A fundamental principle is therefore that court should take whichever course appears to be to carry the lower risk of injustice if it should turn out to have been wrong in the sense I have described. The guidelines for the grant of both kinds of interlocutory injunctions are derived from this principle. That's what I am highlighting. Court should have, my lord, considered, Lion's trial court before granting an injunction should have discussed as to what will happen if today I grant an injunction, tomorrow the suit is decreed, and if I do not grant an injunction, tomorrow the suit is decreed. Injustice will be more if this injunction is granted. That is why injunction should not be granted. This was the relevant consideration. This was not discussed, and the only discussion is that suit is not yet disposed of, 8 months have elapsed, and tenure is, my lord, only 2 years. That is not the consideration, my lord. So that being the position, my humble submission before your lordship will be, your lordship will not kindly interfere with the stay passed by the London First Appellate Court, and the matter may be remanded back. Let the First Appellate Court decide the appeal at the earliest. We are ready to participate in the hearing at the earliest.
No, it doesn't have to be remanded. Only this, they have only challenged this interim stay.
Yes, madam. No, not a question of remand. I'm sorry, madam.
No.
Your lordship direct the
we are discussing
possibilities here. But stay may not be granted by the interim, madam.
Lordship, I have a very small submission to make.
Yes, please. You have a right to. I'll hear you.
My learned senior friend has pointed out about the various intricacies in conducting the election. Now, Lordship, if I had not gone to those intricacies, because those are subject matter of evidence, Lordship, subject matter of evidence, and can be determined only after having the full-fledged trial, Lordship. However, I should point it out now, Lordship, there are not, the illegality is not only one, that only 606 people casted votes and ballot papers were 609. That was not the only illegality. There were several other illegalities. I am pointing out one by one, Lordship. First, Lordship will kindly appreciate, there was cancellation of nominations. Several cancellation of nominations, that is at page 46. Cancellation of nominations at page 46.
Okay.
Sorry, Lordship, for page 81. Page 81. Page 81.
But there's no discussion in the, order of granting injunction.
Yes.
These aspects has a bearing on the prima facie case. And the balance of
order
control.
has been
that
passed.
was not discussed.
Yes, Lordship. That's why also, Lordship, I have not gone into all these aspects at this stage, because these aspects were dealt by the honorable, heard by the honorable trial court below after hearing both the parties, Lordship. There was full discussion on, full hearing on all these aspects, Lordship. But there was no reflection in the order. Similarly, Lordship, in the order of the First Appellate Court, there is, it is even worse, Lordship. There was no discussion at all. It was stayed only because an appeal has been preferred. But I should point it out now, since my learned senior friend has pointed it out, there are several illegalities. One of the illegalities, nominations were cancelled without any reason, without communicating to the parties. I can show your Lordship the document. Then, Lordship, there was no polling or the counting agent in this particular election. Then, Lordship,
That
These,
that
yes.
true, but
Then,
we have gone
lordship,
into it.
then lordship, I should
But we
point it
cannot go
out.
fully into the merits. We are only
Yes.
concerned with whether
No,
the
I am,
temporary stay given,
yes.
whether the prima facie on the face of it, the injunction order has, because
Yes.
even the injunction order is a subject of the appeal.
Yes, I have,
Cannot express much opinion on that also.
yes,
What
I
is
have,
the limited,
yes, I have, that's why shown
you have
only
come up with
one.
limited point.
I have that's why shown only one of the pivotal illegality which can be inferred from document itself without going into oral evidences.
Page?
But my learned senior friend has taken has submitted on the illegalities intricacies. But I should now show it to your lordship because it is my duty, lordship. Page 81, lordship will see. Page 81. Page 81. Few of them I will show, lordship. Few of them I should show, lordship. It is my duty. Page 81. After scrutiny, the following nominations have been found valid. Then lordship will see page 83. Page 83. Nomination cancelled. Nomination cancelled. These nominations have been cancelled. And there is no reason, no discussion, and not even any communication. Not even any communication made to these parties regarding why their nominations have been cancelled. Now, this is one aspect. Then lordship will see, I have stated in my plaint that lordship, there was no polling agent, no counting agent to raise any objection or to observe the election process. I have stated at page 46, lordship. I have stated at page 46. Para 6, that the election was conducted on 5/4/25 and counting was to go on till 6/4/25. However, strangely and against normal convention, no polling counting agent of any candidate was permitted to be present. Then lordship, that my senior friend has already submitted, number of votes was 606. Number of candidates was 606. But number of ballot papers, number of vote casted was 609. How can that be, lordship? If there are 606 candidates who had casted vote, how can there be 609 ballot papers? Now, which of the ballot papers have been found to be duplicate? Which of the ballot papers, lordship, have been taken out?
The margin,
all these things are silent.
Do you dispute this, that the margin of error was not 8 votes? You don't dispute.
Now, lordship,
That's a fact.
No, margin of
it's a fact.
no margin of
Again,
error.
it'll again come at the stage of evidence.
Yes, that is true. But margin of error in respect of all the three petitioners are different. In respect of one, it is 8. In respect of the other, it is 1 single vote. And in respect of the third one, he is re-elected. He is already an elected member even in the new body. So there have been allegations of irregularity and illegality from all the corners.
As far as plaintiff number 3 is concerned, he's seeking setting aside of the election in which he's got elected.
Yes, because there is illegality, and lordship will kindly appreciate even the general secretary, Osim Biswas, he has written several letters. He's
in other words, he's also seeking setting aside of his own election.
Yes, because it is illegal. He is ready to face new election or recounting whatever it may be after the order of the learned court below. But lordship will see even the general secretary, he has written several letters. Page 107, lordship will see. 107. 107.
So much
Biswas
detail.
is the petitioner. Ashish Biswas is the respondent. He is the general secretary of the body. He is the general secretary of the body. Ashish Biswas. NFLM, page 107.
Yes, I'm on
page 107. He has written several letters to all the person concerned. He has written this letter at page 107 to the General Secretary of All India Railwaymen. He has written this letter, subject, only the subject I am reading, information regarding election, office bearers held at so-and-so, conference so-and-so. Second last para, lordship will see. Second last para. Furthermore, scrutiny committee has not issued any official communication regarding the excess ballot papers or provided any clarification on the matter.
I'll have to give again fresh reply. There will be never ending.
As a result,
it's like a full hearing. That's why-
appeal is yet to be heard.
That's why we cannot go very deep on that question also.
I am
Because the merit of the injunction order is being looked into by the appellate court, actually. So only, we are on the merit of the temporary stay by the appellate.
Yes, madam.
Lordship, I am.
And that will be determined by what? In my humble opinion, the merit of the temporary stay by the appellate court would be determined by the what prima facie appears from the injunction or the order of the trial court, whether any error, appears.
And during the pendency of the appeal, whether they should be stay or whether they should be allowed to continue. Ashish Biswas is taking major role in writing letters because if there is a stay of the present elected body, he will continue as the General Secretary. That is the whole intention. That is why he is writing again and again.
Lordship,
And so far as, my lord, the non-acceptance of some nomination paper, they are not before your lordship, my lord. They are not before your lordship. They are not the plaintiff. They have no grievance. It's not a public interest litigation, my lord, that everything and anything will incorporate in the plaint and the court will decide. They must have a cause of action. Plaintiff doesn't have any cause of action. He has been elected. If he is interested in getting elected, he has been elected. In spite of that, he has come so that there is a group, my lord, that earlier group remains.
With all humility, Lordship, I submit that, Lordship, I will reply only to those points which have been made by my senior friend, Lordship. I'll be brief, Lordship. Now, Ashish Biswas, whatever rightly, wrongly, he is the present General Secretary and he is holding a post, Lordship. We should give due respect to the post. So, Ashish Biswas, he has written not only one, several letters to various stakeholders, various persons concerned. Page 107.
He's working, but he's working on, in a sense, borrowed time.
But
right?
he
Because his
is even.
term is expired.
He is even.
No. May I just point out? He is not working. After the elections were over, my lord, there is one factual thing I have to point out to your lordship. These persons who are the plaintiff and their group, they have taken away the ballot box, kept it in a room and under lock and key. They are the custodian. Who are they, my lord? This is the role is being played by them. They have kept it under lock and key, the box and the room. And now they want to continue. They have made a specific averment in the revision petition. If they are allowed to continue, nobody will be prejudiced. Only that issue Lordship will decide, not on merit.
All these are allegations. Let me come to Lordship. Ashish Biswas. Ashish Biswas is the General Secretary of the earlier body. Now, Lordship, he is even in a better position. He is in the working president now under the new body. So, what is his interest, Lordship? He is not at all interested. New body list, Lordship will see. I should point it out, Lordship. New list is at page 167. New list, 167. The present position of Ashish Biswas may kindly be seen. He is even in a better position. Page 168 is the list. He is the working president now. So what interest he has, Lordship? He is not having any interest except the interest of the organization, Lordship. Except the interest of the union. Now, so these letters of Ashish Biswas are very much relevant, Lordship. I should show it, Lordship. Page 107 is the first letter issued by him to the General Secretary of the All India Railwaymen Federation, alleging irregularities. If not he, who else can make these communications? He is the representative of the body. Page 108, Lordship will see. Again, General Secretary, page 108, Lordship will see. He has again written to the all members of the scrutiny committee. Page 108. Page 108.
Yes.
Ashish Biswas. Page 107, he has written to All India Railwaymen Federation. Page 108, he has written to the all members of the scrutiny committee. Then next page, Lordship will see. Page 109. He has again written to the President of All India Railwaymen Federation. Page 109. So whatever was possible on his part, he has done. Now Lordship will see, for a moment, Lordship will see page 163. My learned friend has, now Ashish Biswas is a respondent. He is not a petitioner. That also Lordship will kindly appreciate. He is not a petitioner. He is not an interested party. It is their document.
The ground which has been, written by the trial court that the term would be over and therefore, that is one of the reasons for irreparable, loss.
But
and the prima facie, as far as prima facie case is concerned, where is the discussion prima facie? Where is the discussion
They-
regarding
this-
this?
but
We
there-
have to harp on
Yes.
these things at this stage.
But
actually.
there are submissions recorded from both the parties in the order, Lordship. Submissions are recorded. Now, for a moment, Lordship will see 163. My learned senior friend submission is that we had invited the observer. But this ground I am harping on because this is evident from the record itself. This is very pivotal. 163, Lordship will see for a moment. Again, 163 page. 163. For what purpose General Secretary of All India Railwaymen Federation was called? Page 163. This was issued by Ashish Biswas. I'm reading this letter again, Lordship.
We've gone through it.
No, but
And
he
could
was
not
not.
appear any deputed
No,
assistant.
no, no. He
general.
was not invited as an observer.
Hmm.
He was invited only as a guest to grace the meeting and the conferences. There was a 3-day program, Lordship, a conference and a meeting. And on the 3rd day, the election was held. So he was called to grace the meetings, not to act as an observer. He has usurped his power and acted as an observer. Now, next page, Lordship will see 164. This also my learned senior friend has read. So I am not reading it again. He was deputed as an observer. So how can he be deputed as an observer? There is no provision of an observer under the Constitution. And the RTI reply, and
The
the
constitution, according to the
Yes.
learned counsel on the other side, senior
Con-
counsel, the
con-
constitution
I have
does not lay down the procedure of election. It does not. It does not.
Constitution says election is to be held on the day of the at the time of the biennial meetings.
Mhm.
But if there is no scope of any observer, and the RTI reply clearly states it is the General Secretary of the Union who is to communicate the list to the General Secretary.
Silence about the procedure about observer cannot mean that there cannot be no observer. The
But the
position from the contended by him is
Yes.
that that is a gray area as we discussed it.
So,
That there should be some stipulations. There will be less chance of dispute. Than,
One aspect I will just, they are objecting to the conduct of the observer. First of all, he was appointed an observer. They have never objected. They have accepted it. Officially, he has been accepted, appointed as an observer. Secondly, my lord, on their representation, when the observer himself has declared that for the time being, I am directing that the result should not be declared. That authority you have accepted because that is in your favor. Now you say the observer has got no authority. And all these submissions on merit will have to be considered by the learned first appellate court.
Lordship, I have not yet completed. I'll not take much time, Lordship. I'll not take much time.
Already in 2 hours.
I'll not take much
Other
time.
matters
Very
to
sorry,
be there.
Lordship. Lordship, here what happens, Lordship? There is a duly constituted scrutiny committee, which is at page 80 and page 80. Lordship, you kindly see. It has been constituted to conduct the election in the BGM. It has been issued by the General Secretary before the conducting of the election. Now, who will conduct the election? If not that scrutiny committee. And where is the result of the scrutiny committee? Where is the result of the election? Till today, there is no result of the election declared by the scrutiny committee. There is no result of the election communicated by the scrutiny committee to the railway administration for circulation. So as on today, there is no result itself. So how can an outsider, an observer, come and declare the result and communicate it to the railway administration? And RTI reply is a statutory reply, Lordship, under the RTI reply Act, RTI Act. So it is a statutory reply. It has some force. So RTI reply
But
says that.
petitioner plaintiff number, if the presence of the observer itself was illegal, plaintiff number 3 has participated in that election. Did you challenge? Then answer me another question. Suppose this the observation, the reasoning given by the learned trial court about the reasoning about the irreparable damages. Suppose the suit is dismissed, then what happens to this democratic process? Suppose the suit is dismissed. Then suppose the injunction prevails, they are not the newly elected, rightly or wrongly, persons are not allowed to function. There is a stay, and the suit is dismissed. Then what happens? Then what happens?
Yes. If the suit
Can
is,
they be compensated by money?
no, if the suit is allowed for a moment, if we assume that
No,
if
both
the,
sides are there.
both sides are there. If the suit is for a moment, okay, Lordship, if the suit is dismissed, then Lordship, definitely they will get a 2-year term. Definitely they will get a 2-year term from the date of the dismissal. And whoever is holding as an acting as an office bearer in the earlier list, they will continue. And I have already shown, Lordship, Ashish Biswas is there in the earlier list and the new list also. Dhiraj Chaudhary is there in the earlier list and the new list also. Dhiraj Chaudhary is one of the petitioner. Only 2 persons are there, Lordship. There can be a via media order also, these 2 persons cannot act. That also order also we will be ready to accept, Lordship. But an illegal election by virtue, if suppose for a moment, if we assume that if after 2 years, if after the decision, if the decision goes against their favor, it will amount to what will be the result, Lordship? They will carry out, they will enjoy powers illegally. Can that be recompensated, Lordship? That also cannot be compensated. So learned trial court below, after considering all aspects of the matter, had passed the order, and the learned appellate court below, first appellate court below.
Proceed, this reasoning is not correct. That
First-
the
first
only
ap-
9 months have elapsed, therefore that's not a correct reasoning.
First appellate court below's order also, Lordship, it is no reason, it is no order at all, because there is no reason. It is totally non-speaking order. Totally non-speaking order without hearing the other side. Whereas the trial court's order, it has been passed on contest.
Appeal should be allowed to be heard on merit.
Yes, appeal should be allowed to be heard on merit, but till then, Lordship, this order should not operate, Lordship.
Function,
Till-
even if
yes.
they are not elected.
But till then, Lordship, on the next date fixed, Lordship, on 31 March, the appeal should be heard. And till then, Lordship, this order, because he will definitely be, they will seek time, Lordship, on the next date otherwise.
Let's
Lordship
dispose
may
it.
direct that, yes.
Dispose it.
Yes.
Not very long order.
Sir, Lordship.
We will not go into so many of these details
No,
now at this stage.
Humble
Take
submission.
more
Lordship.
time and it will unnecessarily, it
In
may
my-
prejudice also.
In my humble submission, it is only a matter of 10 days, Lordship. Till then, this order may not operate, Lordship. The order of the appellate court. Appellate
They
court. Because
cannot be
it has
allowed
been
to
obtained.
function.
It
But
is an
they have not
expert
been
order.
elected. How can they be allowed to function? They are not elected. By virtue of their election in 2022, they cannot function beyond the provision
Then-
time granted by the constitution itself, which says 2
Lordship-
years. They have
No,
already
2
functioned
years
for
is-
8 months extra.
Lordship, 2 years is not mentioned under the constitution. It is held biennially. And till the new body.
You have accepted that 2 years.
It
Your
is,
pleading
it
in the
is,
plea.
no, it is generally 2 years. It is because, and till the new body takes up charge, the old body will continue. That is the practice. Till the new body takes up the charge, but there is no stipulated 2 years. But that order in my humble submission
Sharma,
cannot operate.
G.K. Sharma.
Okay, obliged.
Learned counsel for the,
My other matter, may I go? Man?
yeah, he can make it. No issue. We're taking a lot of time. It's short term. The
Lordship, I take it as just Lordship, only one page also. Lordship, only one page. Page 90. Page 90 for a moment, Lordship. Page 90. Page 90. This is the result, purported result, but there is no signature of the scrutiny committee. This has not been declared by the scrutiny committee, and allegation agitation is not only by one person. Allegation agitation is by 3 persons. At the top, Lordship, GS, I being candidate of GS post NFRMU, not agreed to the above. Endorsement, Lordship, not agreed to the above. Result, owing to gross irregularity. Down below the table, Lordship will see, I have objection on the result. So-and-so of gross irregularity. Then below again, Lordship, I have objection. So several persons raise objection, not only one, Lordship. And the observer, he has given his observation over the table, Lordship will see, since one of the candidate for the post of General Secretary has raised objection.
Your Lordship, that aspect has already been clarified in the WS filed by the observer, as has been pointed out by the senior.
So till today, Lordship will kindly appreciate it. Till today, there is no result of the scrutiny committee. No result of the scrutiny committee. Scrutiny committee is totally silent. They have also not been able to produce any result of the scrutiny committee, Lordship. There is no result of the election. So how can the railway administration declare result, Lordship? Circulate result.
the third censor, senior counsel, was appeared for the caveat filed by the respondents who are 27 in number. The caveat stands discharged. The invoking the jurisdiction under Article 227 of the Constitution of India, the 3 petitioners here is have challenged the order dated 2/2/2026 passed by the learned civil judge senior division number 3, Kamrup M. Gauhati, in miscellaneous appeal number 2/26. whereby the learned appellate court was pleased to stay the order dated order dated 19/1/2026 passed by the learned trial court, being the court of the learned civil judge junior division number 2 Kamrup M in Miss J case number 187 of 2025. Before proceeding further, facts in a nutshell, the petitioners as plaintiff, the petitioners as plaintiffs have preferred title suit number 127 of 2025 before the learned trial court mentioned above, whereby they have challenged election election to the challenged election dated 5/4/2025 to 35 post of central office bearers of the working committee of the general body of NF Railway Mazdoor Union, within bracket hereinafter NFRMU. It is stated that the said election was held in its 14th biennial conference. Stop. Containing that, containing that there were gross irregularities in the election, and it has been prayed in the suit to declare the election as null and void. In the said suit, the plaintiffs prayed for temporary injunction, invoking the provisions of Order 39 PPC, which was registered as Miss J case number 187 of 25. After hearing the parties, the learned trial court was pleased to allow the prayer for temporary injunction, and the defendant opposite parties were directed not to undertake any of the duties and responsibilities of the office of the union. The defendants were stated to be elected as office bearers in the aforementioned challenged election to the NFRMU. Agreed by the grant of the temporary injunction by the learned trial court, the defendants took up the matter in appeal by way of, where is the appeal memo? The appellate order was at the impugn order here.
In order, page 328.
Yes, I marked it.
328.
Yes. Which was registered as Miss Appeal number 2 of 2026 before the learned civil judge senior division number 3, Kamrup Metro. And the notice was issued on the appeal. However, in by order mentioned in para 9, the learned appellate court stayed the impugn order of injunction passed by the learned trial court in Miss J case number 187 of 25, as mentioned above. The reasoning given by the learned appellate court is that till the appeal is decided, if the order passed by the learned trial court remains in existence, the purpose of the appeal would become infructuous. Though respond number 28 to 36 have been implemented as pro forma respondents. Both the learned counsels for the petitioner as well as the 27 main respondents have agreed that the matter can be disposed of at this stage and that the same would not prejudice the pro forma respondents. In support of the contentions, the learned counsel for the revision petition has taken the court to the various documents annexed to the revision petition and contended that the result of the election has statutory force as revealed by the RTI reply furnished to him upon his application. RTI reply dated 3/6/2025 furnished to him. It is contended that the learned trial court rightly granted the temporary injunction with regard to the temporary injunction vis-a-vis the suit filed by the petitioner plaintiff. It is submitted that there were gross irregularities in the conduct of the election. It is submitted that the constitution of the union did not have any provision for observer, and yet the assistant general secretary from the central union who was deputed as observer conducted the election and even took up the role of unauthorizedly took up the role of the returning officer.
Lordship, it is not the central union, it is a separate union.
Separate union.
Separate All India Railway.
All India Railway Union, sorry.
Federation.
All India Railway Federation. Now we will not go so much into detail, no? Because it may prejudice only this point and the signs. It is submitted that the petitioners, plaintiffs have been continuing as office bearers from the earlier union, from the earlier tenure, and due to the infirmities in the election which is being challenged, they should be allowed to continue, and the learned trial court has rightly passed the order in that direction by way of a temporary injunction. Taking the court to the relevant annex document in this regard. This submitted that with regard to plaintiff number 2, there was a discrepancy in the number of ballot papers, as the 3 ballot papers were found to be unauthorizedly extra, and thereby vitiating the electoral process, and that the plaintiff number 2 had lost by a narrow margin. Next, on the other hand, summing up his submissions, the learned counsel for the petition submits that while the appeal is being decided, the impugned order, temporary stay granted by the appellate court may be interfered with, as otherwise the petitioners shall be prejudiced. On the other hand, the learned senior counsel, Majumdar, has taken the court to the contents of the order of injunction passed by the learned trial court, and contended that the learned trial court has not properly discussed and recorded findings with regard to the triple test, the well settled triple test of prima facie case, balance of convenience, and irreparable loss. It is submitted that there is no discussion with regard to the aspect of finding a prima facie case. It is referring to para 26 of the order of injunction. The learned senior counsel submits that the observation of the observation and holding by the learned trial court that if the newly appointed body is allowed to function, the main suit may become infructuous is incorrect application of the test of irreparable loss and injury. The learned senior counsel submits that in such a situation, the appellate court, while entertaining the appeal, has rightly put the order of the injunction of the learned trial court on hold because of its prima facie infirmities. I have perused the relevant materials, the orders of the relevant order of the learned trial court and the impugn order of the appellate court. So I've considered the submissions of the learned counsels on both the sides. We can have. That in support of his submissions, he relies on the cites the decision. Okay, Palaswam. Okay. I carefully perused the order dated 19/1/2026 passed by the learned trial court granting temporary injunction. Full stop. With regard to the aspect of prima facie case, the learned trial court has stated that the main dispute is whether the election held in the 66 AGM and 14 VGM of the NFRMU was fair or not. First, it is to be determined as to whether the election process was conducted in a proper manner and in a non-prejudicial manner. The learned trial court held that this dispute has to be determined in a main suit. And therefore, there is prima facie case. The learned trial court has also referred to the discrepancy in ballot paper pointed out by the plaintiff side. The learned trial court has held that the balance of convenience lies in favor of the petition plaintiff seeking injunction. With regard to the aspect of irreparable loss and injury, the para 26 of the said order may be reproduced here in the Uthai. It is at page 291. Sorry, page 291. Full stop. I've perused the para 9 of the order passed by order dated 2/2/2026 within bracket impugn order passed by the appellate court, staying the order of temporary injunction while entertaining the appeal. Para in the case of Thiru Palaniswamy, Supra, the Honorable Apex Court has delved into the principles DLVD, delved into the principles regarding grant of interim relief. After referring to the case of Union of India versus Raj Grow Impacts LLP 2021 SCC online SC 429. Para 73 of Thiru Palaniswamy may be reproduced here in bill. In the instant case, the respondents who were temporarily injuncted from functioning as the office bearers were elected as such office bearers pursuant to the last election, which is of course under challenge in the title suit. The Learned Senior Counsel has contended that Learned Senior Counsel, denying anomalies in the election process, has contended that the injunction order was clearly wrong in prohibiting and barring the office, the respondents who were duly elected in such election. And therefore, the operation of the same has been rightly stayed by the appellate court. Needless to say that the merit of the injunction order is the subject matter of the appeal, and the learned appellate court is in it seized of the same. In this revision petition, this court is only on the limited question of whether the stay of the temporary injunction should be allowed to continue or not while the appeal is being decided. Going much into the details, going into further details of the merit or otherwise of the injunction order would prejudice the determination by the appellate court. However, upon perusing the grounds and the discussion of the learned trial court in the temporary injunction order, and the facts and circumstances which have emerged as contended by both the sides, I am of the considered view that the order of stay granted by the appellate court should not be disturbed at this stage while the appeal being decided. Accordingly, in the facts and circumstances and in such view of the matter, I do not find sufficient merit in the revision petition challenging the impugn order dated 2/2/2026 passed by the appellate court within bracket civil judge senior division number 3 Cambo in Miss Appeal Ima arising out of TS number so and so. Resultantly, the revision stands dismissed and disposed of. Needless to say that despite the docket load, the learned appellate court shall endeavor to dispose of the appeal the earliest convenience. The instant revision stands disposed of on the aforesaid terms.
One small submission.
I've
The
al-
next date before the appellate court is 31st of March, 31st of March. Can an endeavor be made to dispose of the appeal on that date, Lordship?
I see,
Bit
the thing is,
difficult.
I know the ground situation,
Number
the
of cases
metro,
are fixed.
tremendous load,
Yes.
because see that, see, I'll tell you something, believe me, if you make this slightly, understanding observations, it works more.
Yes.
Actually, they get irritated and we have so much work.
Yes.
This can
Yes.
work more, believe me.
Much obliged.
That's why I prefer this.
All right.
Sometimes it may be necessary
Yes.
to fix a date,
All
but
right.
I think this problem is faced in main election petitions also, in parliamentary elections petition also. I mean, when the term gets over, and people has been a minister or something. So I think the solution is to have exclusive election courts,
So the cases, the plaintiff's file,
specialization,
that takes a lot of time.
specific election
And
court,
fast-
panchayat, various kinds of
And
election,
fast track.
election courts.
Motion item 52.
Break level, time like that. Time like that. Supplementary motion. Yes.
Please, my lord, I have filed one petition under Order 8 Rule 1A.
Okay, go to him. Yes, please.
My lord, I have filed one petition under Order 8 Rule 1A3 of CPC for producing the additional documents
That
during
was
trial.
not allowed.
That was rejected, my lord. Impugn order is at page 56. And the main page 56, my lord.
Yes.
And the finding of the court is, my lord, from.
Should we read it? We'll go give notice at this stage, but you can read it if you want.
No, if lordship is so not, only I have the prayer for a stay because the next step is fixed for cross-examination.
Let us read it.
Then paragraph 5, my lord. Upon perusal and hearing of the learned advocate for both sides, it appears that the documents sought to be marked as exhibits are not produced by the defendants.
You're reading para 5?
Yes, my lord.
Yes. Lost.
That is the finding of the court.
Just a minute. We go. Page get live open. Discussion. Apple might have. Sorry. Should we read from the top?
Yes, my lord.
Quickly go through.
From paragraph 3, my lord.
3, yes.
Today is the date fixed for hearing on petition number so and so, filed by the learned advocate for the defendant under Order 8, Rule 1A3 of CPC for allowing the defendant to exhibit the documents marked as Exhibit A, Jamabandi, and Exhibit B, Chitha, which were not produced earlier as listed documents. By this said petition, the learned advocate has stated that defendant had exhibited some documents out of which Exhibit A and Exhibit B were not listed documents, as defendant had no knowledge about the custodian of the originals of the said documents and only come to know about the same after the cross-examination of PW6 and PW7, that is Lat Mandal and copyist of the district report room. Heard learned advocate for the plaintiff, who had raised objection on the ground that the documents sought to be produced by the defendants are not relied documents, and as such prayer to reject the petition. Upon perusal,
Documents ought to be are not relied documents at the time of written statement.
it were not filed, my lord.
Upon perusing.
Upon perusal and hearing of the learned advocate for both sides, it appears that the documents sought to marked as exhibits are not produced by the defendants either at this stage of submission of written statement or at the stage of submission of documents. No leave has been taken by the defendants at any stage of the suit for production and submission of documents at the stage of evidence. Moreover, the defendants nowhere in the written statement cum counterclaim has stated that the documents sought to be marked as Exhibit A and Exhibit B are relied documents and no reason has been shown for non-production of such documents at earlier stage of the suit. Hence, in view of the above, I deem it fit to reject the petition.
Okay.
But my submission is that, my lord, order at Rule 1A3
Have to see. Yes.
that gives a second chance to the order at Rule 1A3.
Rule 1A.
1A3, my lord.
This one, no?
Yes.
Yes. Okay, that's the
My
provision.
lord, my submission is
refresh.
that this provision gives a clear chance, second chance to the party to produce a document which are not produced earlier, my lord. And in this case, my lord, I want to produce the chitta as
But,
well as
that's okay. But leave has to be taken as
Leave,
the learned
yes,
trial
the-
court has mentioned.
yes,
No
that's-
leave was taken.
no, earlier no leave was taken. That's why I have filed one petition under order 8 Rule 1A3, my lord. I have annexed the petition, my lord. And my lord, that petition is at page 51.
That
And
means in the petition which you filed before the learned court, you sought leave, you sought to invoke.
exact wording,
one,
word is not, but the provision is mentioned, my lord.
Yes, no, it is always the substance which should matter.
The provision
Should
is
matter.
mentioned, my lord.
One word should not.
Word is exactly not there, my lord, page 51.
What is the stage of the case?
The stage is, my lord, the evidence on affidavit of the DWs are already
Will you
filed.
be prejudiced if it is not stayed till the next day?
My lord,
Or
it
it can,
is- it
we
is-
can make it should not, it may not be disposed of, but we can make an observation to that extent.
My lord, the
Let
only
them talk.
problem is that it is fixed for.
We'll have to see the interpretation of this provision.
No, my lord, I have the judgments if lordship wants to see, my lord.
Have to look. Because on the aspect of stay, otherwise,
Yes, my lord, it is
if you are
fixed-
seeking stay, we'll have to go
yes.
little further. Otherwise, only notice, we'll not
It is for cross
spend much
examination.
time.
Yes, sir. It is fixed for cross examination. That's why the difficulty, my lord.
Because these stays delay a lot, no? You all know that, but sometimes it has to be given what to do.
Lordship may kindly first take up, my lord, AIR online 22 SC 244. My lord, I'm reading from paragraph 2 onwards, my lord.
Yes.
Paragraph 2, we find that the trial court as well as the high court have gravely erred in law in not permitting the defendants to produce documents, the relevance of which can be examined by the trial court on the basis of evidence to be laid. But to deprive a party to the suit not to file documents, even if there is some delay, will lead to denial of justice. It is well settled that rules of procedure are handmaids of justice, and therefore, even if there is some delay, the trial court should have imposed some cost rather than to decline the production of the document itself. Then this appeal is allowed, my lord. Then another judgment I have relied, my lord. Both are on the same, my lord, order at 1A3, my lord. That AIR online 22 SC 807, my lord.
Yeah, 807.
My lord, lordship may kindly come to my lord second page, my lord. Here, my lord, the order A, orders 8, my lord, quoted, then, my lord. Second page, my lord, sub rule 1.
Yes.
There is subpara, may I read, my lord? Sub-rule 1 mandates the defendant to produce the documents in his possession before the court and file the same along with his written statement. He must list out the documents which are in his possession or power as well as those which are not. In case the defendant does not file any document or copy thereof along with his written statement, such a document shall not be allowed to receive in evidence on behalf of the defendant at the time of hearing of the suit. However, this will not apply to a document produced for cross-examination of the plaintiff's witness or handed over to a witness merely to refresh his memory
Sub-rule 3 states that a document which is not produced at the time of filing of the written statement shall not be received in evidence except with the leave of the court. Sub-rule 1 of Order 13 of CPC again makes it mandatory for the parties to produce the original documents before settlement of issues. Sub-rule 3, as quoted above, provides a second opportunity to the defendants to produce the documents which ought to have been produced in the court, along with the written statement, with the leave of the court. The discretion conferred upon court to grant such
Right.
leave.
Well, why is the court then, when you file the application, do you have the application which you filed
Yes,
for
yes,
the?
my lord, that is application is
So-
that, my lord.
so the no leave.
Page 51.
Just a minute, no? It appears the documents ought to be marked. Because that part is correct. Leave has to be taken. I mean, the permission, forget the word. The permission to adduce, that has to be taken.
That
right?
page 51 is the petition. Starts from page 51 and the reason is at page, the paragraph.
Oh, yes. You marked the petition as order 8, rule 183.
183. Exact word leave is missing. I have not.
Not matter. That would be
But
hyper
the-
technical.
and the reason
That
why.
would be hyper technical
Yes,
approach.
and
That, it should be there. Ideally, it should be there. That's the most important word.
Yes.
But substance is more important.
Substance is, and even the reason why it was not produced earlier and all the things are stated in the petition, man.
Anyway, so let's not spend much time till the returnable date. Let him come, we'll dispose it
Yes,
of.
yes, my lord.
Because are these things not, your suit will get
Yes.
delayed. Heard Mr. Gupta? A.K. Gupta, Land Counsel for the petitioner. Let's stop. Invoking 227 Constitution of India. Challenged order dated 21/1/2026 passed by learned Civil Judge Junior Division number 1, not looking for, in TS 26 of 24, whereby the learned trial court was pleased to reject petition number 1736 of 2025, filed by the petitioner as defendant to adduce additional documents. Full stop. The learned trial court noted in para 5 that these documents were not produced at the time of written statement, and no leave has also been taken to reduce the same. And therefore, the proceeded to reject the petition, leading to the grievance of the petition who's before this court with the same. The relevant statutory provision is Order 7, Rule 1A, subsection 3, Rule 3, sub-rule 3, which lays down that a document which is to be produced in court by the defendant under the rule, but not so produced, shall not be so produced without the leave of the court. Anyway, the learned counsel has drawn my attention to his petition pertaining to the matter. I find it in the cause title, it is marked as, it is mentioned as a petition on the order 8, rule 1A subclause 3, TPC. In support of his contentions, he is also relied upon following decisions, so and so, and submitted that it has been laid down in these decisions that the party should be given a second chance to adduce relevant documents, and that being a matter of procedure should be interpreted in a justice-oriented way, and that, like in one of the cases decisions cited, appropriate cost can be imposed if necessary. The learned counsel prays for stay of the suit till the stay of the suit, which is stated to be at the stage of cross-examination of PWs, plaintiff witnesses. Issue notice upon the respondent. However, in the given facts and circumstances, the further proceedings, TS so and so, pending in the court of so and so, will remain state till the next date of listing. This remain in the file, helpful for the next court. Very slowly. So list after notice will be necessary. At least 3 weeks will be necessary. 4 weeks.
After 4 weeks, because the notice has to be served.
List after 4 weeks. It will be better to fix a date since there is a stay. List after 4 weeks on in April 20 April. On 24 Friday. No.
Published.
And. Yes, I may allow.
Not prepared. Yes. So. Adjournment in this matter, personal difficulty. Where is allowed after issue notice.
Already notice has been issued, also we have taken a step, but.
Let me see, the office no. I waited. The matter after a week on it to be fixed by registry model. Did it on 31/8/2000. Long time, you know?
Yes.
Pending for a long time.
Yes.
Interim order shall stand extended till the next date of listing.
Highly available.
We'll try to dispose it of.
I am appearing in item number 9. 8 is also similar matter, my junior friend. If I take your lordship to item number 9.
Item number 9.
Impugn order is at page 65. For going into the interim order for your lordship's convenience, if your lordship kindly comes to order dated 1st of October 2024.
Yes.
Asked by this honorable court. Lordship will be.
So there's also an order of stay. There is also an order of stay.
Yes, my lord.
But the other side has appeared. You are appearing.
Last occasion, there was a question
In both the cases, you are the respondents. Yes, please go ahead.
Question arose under what provision of law he filed the application. The application, your lordship will find it annexure 6, page 56. And prayer portion is at page 59. I will take your lordship to prayer portion.
Page 56.
Page 56, the petition starts, and page 59, if your lordship kindly comes for prayer. Directing the so-and-so to submit all the information about the sale of the suit property. My lord, I have gone through the CPC, I have not found this kind of provision. The order 11, my lord, there is a provision. Order 11, rule 14. Production of document, my lord. Not information. Information is not available in CPC, my lord.
Who is the impugn order?
Impugn order is at page 65. Whereby the
Page 65.
trial court has directed us to furnish the information.
21/8/2024.
My lord. Operative portion, your lordship will find.
We can go through it once.
Well, the other things are this regarding fact of the case.
Accept the case. The operative
Not
part is
necessary. 70.
70.
Yes.
Challenging the, it is, we can read from here.
The paragraph, it is seen that the plaintiff has filed this suit challenging so-and-so. And so-and-so, so-and-so. In view of the fact that the defendant number 1 to 5 executed deed of development in favor of so-and-so and defendant number 6 and so sold the constructed flats to the prospective buyers, the prayer of the plaintiff directing the defendants to furnish the names of the proposed buyer is found to be justified. My lord, the question is under what provision of law, my lord? The sole question before your lordship. If your lordship kindly.
He is seeking his share as a son of the deceased.
My lord, whatever I do not dispute, my lord. Fact of the case is different, my lord. Law is different, my lord. So whether under the provision of CPC this kind of petition can be allowed.
What about 151? Anyway, let's come to that. You think there is no statutory backup
No, my lord.
to pass such an order?
Under order 11, rule 14, there is a production of document.
Petition was filed. The petition was filed under.
Oh, the legal provision was mentioned, lordship.
No legal provision was mentioned.
Page 56. The last occasion, this honorable court was given time to my friend to justify under what provision of law this petition.
Okay. Let us proceed. So this is our
This is
contention.
limited case, my lord.
No statutory backup.
Order 11, Rule 12, application for discovery of documents. Read with Order 14, production of documents. Read with
Order.
Order 11, Rule 12, application for discovery of documents.
Overview of documents. Yes. Read with.
Read with Order Rule
14.
14, production of documents.
Yes.
Read with Section 151 of the CPC.
Order 14, you're saying? No.
Order 11,
Oh,
Rule 12,
read with.
Rule 14,
Rule 14 of Order 11.
Order 11, lordship,
12 and 14.
and 151.
Anyway, so that according to you can be passed under
What
this.
happened in this
But
case?
there is no
lordship?
reference to the,
Lordship, what happened in
provisions,
this case?
either in the application or in the order. There's no reference to statutory provisions
There
either
is
in
no
the
reference to
order
statutory
or in
provision
the
either in the
application.
petition or in the
Or in the
order, lordship.
application. That is one deficiency.
Such an
Anyway,
order can be passed.
let us see. Your reasoning is. Okay.
What happened in this matter, lordship, during the pendency of the plaint, lordship, the suit filed in 2019,
By you.
filed by us, Lordship. We have also filed one for order 37 Lordship for injunction. However, that was not even granted, not rejected, but that is pending, Lordship. So in that matter, Lordship, after we filed the suit, we have done a copy of the suit and submitted a written objection to the Deputy Commissioner's office and the Circle Office, Lordship, not to transfer the property. But the same was allowed at the back of us, and subsequently, Lordship, most of the flats has been sold. Thereafter, we tried to apply for the certified copies of the sale deeds. Those were not made available. So, Lordship, by resorting to this provision, since we don't have the exact knowledge of the documents, we sought information from the defendant to provide us the sale deeds because they are well handy with the documents, Lordship. They have executed the sale deeds, Lordship. So this provision helps us, Lordship. Section 52 of the Transfer Property Act bars any transfer during the pendency of a suit, Lordship. Even though we have mentioned all those things before the circle of officer as well as the Deputy Commissioner office, but still that has been done.
Why is sale deed has not been provided to you? Certified copy? Sale deed certified copy, I'm saying.
Lordship, it was manual at that time. Have not been able to procure the certified copies of the sale deeds, Lordship. And more than 200, around 200 flats, Lordship, been sold. That's why we are facing the practical difficulty.
By this petition, which is
Lordship,
for to statutory provisions, you are seeking names of those buyers.
we are seeking the details of the sale deeds executed by them. Lordship, may please come to para 59. Ninth prayer of our petition, Lordship. Pass an order directing the defendant opposite parties to submit all information about sale of suit property, such as information about sale deeds, name of respective buyers, allotment of property to the said buyers, number of flats left to sell, etc. on the next date fixed by the Honorable Court. So this is the information. Since we are in dark, we don't know who has purchased, how many flats has been taken. Since Section 52 of Transfer Property is under operation, Lordship, that has been violated. So we do not have any knowledge, Lordship. That's why we have sought this information from the.
You have to go to some extent, at least into the merits of the matter. What was the suit filed for? What was the dispute about? We have to go to some extent. Otherwise, it is true that the substance matters, but still there should have been some reference to the provision under which is being invoked. No? Even if it is 151, that's a blanket power. 151, interest of justice. Yes.
Page 26 onwards, Lordship, that is our prayer portion. Basically, we want share of our share in the partnership business, along with other benefits, Lordship, because prayer clause, page 26, prayer 1B, declaration that on the basis of the deeds mentioned in Schedule B of this plains, the defendant number 6 and 7 have no right and authority to alienate, sell the Schedule A land and the flats, buildings situated. Lordship, these are pertain to the main prayer.
The provisions, I mean, looking at his point of view, is that these provisions which you are referring, that the power exists, but there is no reference either in the petition or in the order.
Or in the order, there is no reference, Lordship, but that does not make it a battle to the matter, Lordship.
Or should we send it back to conduct the exercise once again, or it will not serve any purpose? It will delay. Specific what is being sought for, even if it is, as I said, 151. It has to be just you're right actually to that extent that it is just a land on this side also, and on the order also is like that.
All respect to my friend. We gather information and then we file suit. It is not that we file suit and gather information from the defendant. Where is the provision? What my friend is relying is different. Look, this order is expressly illegal. There is no power in the trial court to pass such kind of order. And what prevented my friend from applying before the Deputy Commissioner and the RTI? There is nothing in the petition filed by the respondent, my lord. Any document, no document is there, my lord. Page 56, your lordship will see there is no document. That he have applied this, that.
Page 58, para 6.
My lord, no document.
Page 58, para 6 of our petition, lordship. May I read, lordship? Para 6, page 58.
This is
After getting knowledge of the plaintiff
part of the
petitioner
petition.
and lordship, that is our petition, copy of the para 6, lordship. That after getting knowledge, the plaintiff petitioner inquired before the sub-registrar Kamrup about registration of any sale deed executed by the defendants in respect of the suit property. However, the plaintiff petition could able to get information about some of the sale deeds only, but failed to get entire information about all the sale deeds due to lack of cooperation from the office assistants of the sub-registrar office. Therefore, the plaintiff have compelled to file this petition praying before the Honorable Court to pass an order directing the defendant to submit all the information about sale of suit property, such as information about sale deeds, name of respective buyers, lordship, on the next date, so that plaintiff can take appropriate steps with regard to new facts and circumstances.
Sir, I do not dispute his statement. I dispute whether he has submitted any document to substantiate that part of the claim. There is no document, my lord. Let my friend say that he has submitted any document. My lord, what prevented him from applying before the deputy commissioner and the RTA, my lord? He is seeking an information from a suit.
Kindly see, we have given a written objection along with a copy of the plain that these properties under litigation do not transfer.
My lord, there is
But
no
they have
document.
transferred, lordship.
My
They
lord,
have transferred.
There is no document in the suit, my lord. Here statement, my lord.
No, the lease pendants, what it says is that
Section 15.
the sale is not invalid, but it will be subject to the outcome of the
Out
suit.
of the
Therefore, people should not do not enter into that complication. They do not transfer at all. Because it will be subject to, because third party rights may be created that lead to its own complications. So otherwise, per se, the sale will not be invalid, as you know.
I'll just
Yes,
read the
ladies
52,
More
lordship.
than
One small effect before my friend starts. My lord, as on this date since 2019, my learned friend has never pressed for injunction. Now he is saying before this honorable court under section
we
65.
can set this aside and then
Lordship.
you may.
Lordship.
No, I mean, this is actually appears to be, I find some force in its contention. So on the face of it, this can be, then you can file a fresh petition if you want. Remand it, for remanding also, it has to be set aside. And then you can file a fresh, then you can look up the law, look up the petition and file a petition invoking the appropriate sections. And are you seeking production of documents? That provision is there.
That provision is there.
But it has to be, you have to take recourse to a particular provision, isn't it? At least, if not anything else, at least the residual provision of 151. So from that perspective,
liberty may be
this
granted.
contention is the right action. This is, petition in a court cannot be like a letter, right? So it has to be some more specific. Anyway, I think that
Lordship, liberty may be granted.
Hmm?
Liberty may be granted.
so it will have its own implication, it will cause
Yes,
some
yes.
delay, but anyway. Much friendly. Have a seat. Mr. Das.
H. Das.
Other in 8, your appeal. Your name also. B. Thakuri.
A Kakoti.
Right.
M. Borua.
Stop. Yes, the title suit being TS number 447 of 2019 in file Judge number 1 Kamrup M. where
Pending in number 2, my lord.
number 2 now, yes, number 2, where one of the prayers of the plaintiff is a declaration that on the basis of deeds mentioned in Schedule B of the plaint, defendant number 6 and 7 declared declared to be having no right and authority to alienate / sell the Schedule A land and the flats and buildings situated over Schedule to any person, unless and until the plaintiff gives written consent as the legal heir of late Swapna Banerjee, who was stated to be a partner in a development agreement deed number 3613 dated 5511 and rectification deed number dated 16/5/2012. The plaintiff petitioner, the filed an application before the learned trial court. The prayer that the other side be directed to submit all information regarding the sale of good property during the pendency of the litigation, including sale deeds, information about sale deeds, name of respective buyers, allotment of property to the said buyers, number of flats left to sell for the court, trial court. The opposite parties submitted a written objection to the said petition. And after hearing the parties, the learned trial court within brackets, Civil Judge Senior Division number 2 passed the impugn order dated 21/8/2024, allowing the said prayer and directing respondent to directing the respondent to directing the opposite parties, you write opposite parties, to furnish the names of the prospective buyers. Learned counsel. Revision petition. No, it is that no provision of law has been referred to or mentioned in the impugn order, and the which the said order has been passed. Therefore, said order without an authority of law. It is also submitted that the petition filed by the filed this connection, which led to the passing of this order, also does not mention about any provision of law. Submitted by the learned counsel that as a situation, impugn order is without jurisdiction and should be interfered with. On the other hand, herein submit that said order can be invoking the order 11, rule 12, 14 of the read with section 151 of C. Also submitted that the purported sales of the property / flats been done during the pendency of the litigation, thereby violating of section 52A of the Transfer of Property Act, incorporating the principle of pendants. I perused the relevant materials and I have considered view that the matter is itself. it's well settled that 151 CPC provision of the court wherein orders can be passed. Of justice. Preventing abuse of the process of the court. Well settled that when specific provision is there in the code governing a certain power, usually the powers under 151. It only saves the inherent powers of the court, thereby a residual provision which meant to be exercised in situations where no specific power is conferred available in the court and order the interest of justice. Order 11, Rule 12 and 14 may be reproduced here in bill. And 14 reproduced here. On considering the matter at hand and perusing the materials, I find it to be correct that the application filed giving rise to the impugn order does not respect any provisions under which it was filed. And to that extent, the submission of the learned counsel is correct. The impugn order so has narrated some factual matrix of the matter giving rise to the petition. Not referred to any provision of law and merely allowed the prayer of the petitioner, prayer of the applicant for correction to the defendants to furnish the names of the prospective buyer. In the accepting the contention of the petitioner side, trying to set aside the impugn order, however, giving liberty to the respondent side to ventilate their grievances before the learned court below, taking recourse to the appropriate provisions of law. Such view of the matter, the impugn dated so and so, I'll give him 21/8/2024, passed trial court, learned civil judge senior division number 2, yes 447 of 2000. Set aside. However, as indicated above, opponent side would be at liberty to ventilate their grievances in this regard. Ventilate their grievances by taking recourse to the appropriate provisions of the law. Revision stands allowed and disposed of on the aforesaid.
Obliged, Lordship.
Vote item number 8 and 9, my lord.
Same order.
Obliged.
Common order will pass, 8 and 9.
May please. Appeal, my lord, challenge order dated 10/9/25. Start from page 66, my lord. 11 pages, my lord. My lord, the facts of the case are, my lord, petitioner and respondent, my lord. Their fathers own a plot of land, my lord, and they constructed a building in the year 1989-90, my lord. Ground floor, first floor, and second floor, my lord. Ground floor was, my lord, commercial. Shops are there, and both the parties are, my lord, partition between them. 50% rent is taken by the petitioners.
Their siblings, brothers,
Brothers, my lord.
brothers.
My lord, only dispute is, my lord, at that time it was constructed ground plus 2, my lord. So first ground floor is, my lord, rented out to different tenants, my lord. There is no dispute about the occupation and rent, my lord. First floor is occupied by, my lord, the petitioners, and second floor was occupied by, my lord, the respondent side, my lord. Now, my lord, third floor was open at that time. So on the third floor, my lord, there was a water tank, etc., my lord, and both the parties used to common use, my lord. Now, my lord, in the meantime, my lord, these respondents, my lord, now the petitioners are, my lord, their father and mother, they were expired, my lord. Now the respondent, they tried to construct third floor, my lord, without any permission, my lord. When these petitioners objected, my lord, there several disputes when they also lost some affairs, the petitioners also lost affairs, my lord, dispute arises. Even then, my lord, they filed this suit.
Is the impugn order?
Impugn
Other side is
page
not
6,
appearing?
start from page 66.
Other side is not appearing?
Today, my lord, first time again. So for the first time it is listed, my lord.
The name is shown.
No, no, my lord, it is wrongly shown. It is my name, my lord. Actually, petitions are my colleagues, my lord, and my
It
name
should
is
be under, your name should be on the other side.
my lord, my lord. They have not, so my lord, let notice be. Will may be admitted, notice may go.
Just tell me still the impugn order, because I'll just take it. Convenient for.
They start from page 66, my lord, and
photos.
relevant portion page 74, my lord. 70. There are 11 married.
What, Jesse Holland. The junior's name also, a good name, please. You can give your name also. Learned counsel for the petitioners who invoking the provisions of Order 41, Rule 1 are read with Section 4 of the Code of Civil Procedure. File this first appeal against order against the agreed by the order dated 10/9/2025 passed by the learned civil judge, senior division number 1, Kamrup M. Gauhati. Ms. J case number 432/2025 in bracket arising out of TS number 289 of 2000. Full stop. By the impugn order, the learned trial court pleased to reject the prayer of the appellants, 20 petitioners for temporary injunction with regard to property in person. I've perused the narration in para 11 of the impugn order. The learned trial court observed that the opposite party was in possession of that property and therefore granting of injunction would inconvenience them. That's in that view of the matter. Proceeded to decline the prayer for temporary injunction. The appeal is admitted. The appellant side shall take steps of notice upon respondent defendants who are 4 in number. You will take by speed post. By speed post. Call for the scan copy of pertinent case record from the court of the learned civil judge, senior division number. You just write the Miss J number. Miss J case would suffice, not the whole suit, not necessary. List after 4 weeks. Okay. Should I fix a date or leave it to the registry? I can fix a date. 29/4. Oblige.
Wait for your lordship.
Yeah, for the. It will be discharged.
An appeal under order 43 rule 1R,
Junction.
dealing an order of temporary injunction passed by the trial court.
Yes.
What has happened, my lord? There is a way bridge.
The way bridge.
Yes, it belongs actually to the plaintiff respondent before your lordship, and was not being operated for some time. Then the plaintiff has entered into a agreement with the defendant before your lordship. And that agreement is very important, my lord. We have submitted documents, my lord, annexing that agreement, which your lordship will find at page 48, my lord, of the second bunch we have just now furnished, my lord. Green flag is there, my lord.
48.
Yes,
Yeah, this one. You're representing all the 3 respondents?
Yes, I have filed revocable.
No, one? No.
One caveat.
Okay.
Page 48 is the agreement, my lord. All agreement, my lord.
Page 48.
Page 48. Agreement, deed of agreement executed on
No,
second
page 48 of your,
of this bunch of documents, my lord.
I have just.
oh, here.
Yes.
Oh, sorry. I was looking at
Possibly it's a running page only, my lord.
that.
Page 48, lordship will find the agreement which was executed on 2nd of March 2020.
Okay.
Between the first party, the plaintiff, and next page, page 49, my lord. Second party's name is there, who is the appellant before your lordship.
Defendant.
Second paragraph, lordship will kindly see, whereas the first party is the owner of a way bridge, which is under name and style of Mahalakshmi Way Bridge, situated at northeast Gitanagar, etc. Then next paragraph, and whereas the first party, due to some unavoidable circumstances, is not in a position to run the said way bridge, and as such, the first party approached the second party to run the said business, and the second party has also agreed with the proposal of the first party on the following terms and conditions. Number 1, first party has allowed and authorized, but kindly say, allowed and authorized the second party to run the said business of. Next, the first party and the second party shall bear all necessary expenses required to repair the said way bridge equally to make it in running condition. Third is the second party shall be at liberty to appoint employees, laborers, etc. for running the said business. Then fourth is second party shall be at liberty to run and the said business according to his wish and desire without any interference from the first party or her agents or representatives. Fifth is all the profits incurred from the said business shall be distributed equally between the first party and the second party in the ratio of 50-50. And lastly, my lord,
that if any dispute arises between the first party and the second party in respect of the sale breach, then the matter will be settled under the provisions of law within the jurisdiction. Honorable Court. But basically, there are three things
The expenses have to be paid both of them,
equally.
but no ratio is indicated.
No ratio is indicated. Now, the agreement is very simple, my lord. She was unable to run the weighbridge, so she has approached the defendant has agreed, and expenses were borne equally for the purpose of bringing it into the running condition. And so far as employees are concerned, the
Second party
and profit and share loss sharing ratio is 50-50. That is the business, man. Now, it was going on very well. Later, my lord, on 2nd of August 2025, the plaintiff issues a notice, which your lordship will find at page 51 in this bunch of documents itself.
Dated
2nd of August 25, page 51.
document is dated 2nd March.
Yes, madam.
2nd March. Then the notice.
Legal notice comes on 2nd of August 25. A little more than 5 years. Legal notice is the foundation of the dispute between the parties, my lord.
The legal notice?
My lord, page
No,
51.
no, this is not the legal notice, sorry.
That my client is the
No,
absolute
I am on
owner.
the page number.
Page 51, my lord.
Oh,
If my number one, that my client is the absolute owner of a plot of land as well as weighbridge, namely Mahalakshmi weighbridge. Number two, that my aforesaid client had entered into a deed of agreement on 2nd of March 2020 to run the business, etc. on certain conditions. That is there. Paragraph 4 is important. That you have been running the said weighbridge, page 52. Page 52. You have been running the said weighbridge since the date of agreement, and initially there was no dispute. Thereafter, passing a few months, you have been indulged in various malpractices which are contrary to the contract law. That you are not disclosing the actual monthly income of the said weighbridge business from my client, and also very irregular in paying the monthly share of profit to my client. 6, you had obtained a trade license in your name bearing number so dated in respect of the said weighbridge business for the year 22-23 by manipulating documents, etc., without my client's consent and knowledge, which is criminal offense. However, such effort on your part was thwarted by my client, and my client have sufficient documentary evidence against your said misdeed. The rewards said activities are beyond the terms and conditions of the agreement dated so and so, and it is submitted that to enlighten you that any unfair activities in contrary to the law invites cancellation of the agreement, that you have been exposed to repeatedly indulged in illegal activities beyond the terms of the agreement dated, that my client is suffering from multiple disease and educated unemployed son, daughter, that my daughter's son want to do some other business over the said weighbridge plot as the said existing business, a loss-making venture for my client. Lastly, that I have clear instruction from my client to inform you that my client does not want to continue the said weighbridge business from 10th of September 2020. Kindly note the date, 10th of September 2025, and you are hereby further informed you to settle all books of accounts during this meet period and hand over the necessary documents, outstanding dues, etc. to my client on or before 5/9/2025, failing which my client will solely close the said business. Then, my lord, next page, page 54, we have given a reply.
okay.
Paragraphs will suffice, my lord. In the reply, you lordship will find paragraph 4, that averments made in para 5 of your notice is denied in total by the client. As per understanding, your client has been getting her legitimate share of income regularly. Then para 5, that averments made in para 6 of your notice is false and my client has denied it in toto. These are false allegation of your client to grab the running business of my client who has invested his up and make the way bridge workable condition. Rather, your client has used to demand money illegally from my client despite receiving a due share in the profit. Lastly, my lord, that averment made in para 7 and 8 of your notice is not correct because of the fact that my client with his hard work and dedication has made the way bridge business as sustainable one from lost, but the greed of your client has never ended, and now seeing the said progress, she used to demand of money and used to threaten to close the business. The reply. Basically, the notice has been given for closing the business on the ground that she has not been receiving her share. One allegation is there that some trade license was obtained in his name and
Without informing
the plaintiff. And para 7, it says that her son is interested in opening some business, same place. Basically, she wants to hand over the business to the son. And given on 10th of September 2025, that fee breach is, my lord,
terminated.
yes,
From that date.
yes.
Okay.
This very clearly.
So
I
this
do
was
not
followed
want
by
to
the
continue and
suit.
say with business from Swen. Yes, practically from her side, unilaterally terminates the from 10/9/2025. In this background, my lord, this suit has been
The
filed.
agreement, there was no stipulation
No,
regarding
no,
how to end it. But anyway,
no, my your lordship is absolutely correct. There is quite relevant. Agreement between the parties doesn't provide for termination of the
time frame of the agreement.
time frame is also not there.
Anyway, we'll come to that. Then thereafter, the suit was filed.
There of the suit. Now, lordship will kindly have a look at the plaint. The lordship will find at page 16.
Was filed.
I'm straightway going to the prayer matter at page 34.
Just a minute. Prayer portion?
Prayer portion, matter, page 34.
Yeah, let- no doubt, Chiranjeev.
Yes. Is a decree declaring that the notarized deed of agreement dated 2/3/2020 executed between the plaintiff number 1 and a defendant to enter into a partnership for running the business of Weybridge, namely Swen's solved with effect from 10/9/2025 in terms of the legal notice dated 2/8/2025. Secondly, a decree declaring right title and interest of the plaintiffs over the Schedule A plot of land and the right title and interest of the plaintiff number 1 over the machinery such as electronic scale, along with all its ancillary installations of the aforesaid way bridge, namely so-and-so bridge situated on Schedule A plot of land. And lastly, for eviction of the defendant. And then a decree for recovery and delivery of first possession of the machinery, such as so-and-so is so-and-so. This plaint, my lord.
The bridge and this RCC room.
Yes.
Which was used as office.
Yes. Practically, the entire assets involved in this business are sought to be taken away. Help of a decree in the civil court, my lord. Removing his man and materials. Lordship will find along with the plaint, suit is all right, no difficulty. Now, along with the plaint, they have filed an application for injunction. Lordship will find at page 41, it starts, my lord. We can straightway go to the prayer portion. Page 62. Page 62, my lord. Therefore, prayed that your honor may be pleased to pass a temporary injunction, thereby restraining the opposite party or his man and servants from running the aforesaid business of Weybridge, situated on Schedule A plot of land, till the disposal of the connected titles. There is a prayer.
Is the nature of the injunction order given?
Now, the order
What is
starts
the
from page
petition?
66, my lord. Lordship can straightway go to the operative part at page 72. Page
An ex parte order.
ex parte order. Page 72, my lord. It is concluded that the issuance of an order of page 72, para 16, I am reading, my lord.
Is 72.
My lord,
Just a-
pretty part of the order. My lord.
$71,
Page 70,
$72.
para 15. Consequently, the court at this stage determines that sufficient ground exists to issue an order of ex parte ad interim injunction, thereby waiving the necessity to provide notice to the opposite parties at this time. In such a situation, the balance of convenience will lie in favor of the petitioners. My lord, when the learned, I'm just pausing for a moment, my lord, when the learned court below says waiving the necessity to provide notice, my lord, lordship is aware. It is now very clear that if no notice is given, ex parte order is to be passed, court has to justify it. That issuance of notice will be prejudicial to the plaintiff. That is not there. It says that is the reason in such a situation, the balance of convenience will lie in favor of the plaintiff. Now, para 16. It is concluded that issuance of an order prohibiting the OP from running the business shall not undermine justice during the pendency of the main suit. I do not know how, my lord. Business stopped. I am running the business. I am being restrained. Now it says it will not undermine the justice. Now, lastly, it is very important. The order of ex parte ad interim injunction is specific in nature. Defendant is only restrained from running the aforesaid business of Weybridge in the name and style of Messrs. Mahalakshmi Weybridge, at least till the next date when the OP will appear and file his written objection. My submission before the lordship will be, this is absolutely a ex facie illegal order in the sense that till the next date, nothing should have been done to restrain the defendant from running the business. Now, the court,
Anyway, so
a running business has been stopped. Now, I will go to the grounds on which I am assailing this
the
order.
plaintiff wants to end the business.
End the business. Now,
She was the
lordship-
owner. She is the
Yes.
owner.
Yes.
Anyway, I'll go through the entire order.
I need,
Yes.
we did not go possibly at this stage to the entire order. I'm just raising a few points for your lordship's consideration, my lord. First of all, my lord, lordship has seen in the plain, there is no prayer for any mandatory injunction. And it is a settled position of law, my lord, apart from the fact that there are some judgments which I'll just cite, which says that if there is no prayer for a mandatory injunction, there is no question of granting any temporary injunction.
Yes. That's
My lord, there are judgments, I'll cite the judgments together, my lord, other judgments.
only
are okay.
declaration.
My lord, yes.
Only declarations.
Yes, ma'am.
Or
And the
declaration.
position is there, but then there is no prayer for permanent injunction.
Yeah, no,
And-
all the four prayers are of declaration.
Declaration. One and two are declaration, three is for eviction, decree for eviction, and
Oh, yes.
fourth is for recovery and delivery of cash possession.
Declaration,
Same.
eviction and recovery.
C and D are more or less same. For eviction and recovery of possession. My first,
Of course, the residual thing is there, but no
Yes.
specific permanent injunction prayer.
my first submission is that in the absence of any prayer for a mandatory injunction, there is no question of granting any temporary injunction, which is the settled position of law. Thereby, my lord, the learned trial court has acted beyond jurisdiction and which has resulted in serious prejudice to the petitioner before lordship with the defendant. Now, apart from this, my lord, what is the case here? My lord, the plaintiff in the plaint has clearly mentioned that I have issued the notice. There is a reason, my lord, why they have put a particular date. According to them, the partnership business, and they terminated or rather dissolved the partnership by issuing a notice. There is the reason, my lord. They have, or she will kindly just one sentence I'll show page 31, para 37. That is the whole basis of their suit, my lord. Para 37 at page 31. The plaintiff state that the aforesaid agreement dated 2nd of March 2020 is an unregistered agreement of partnership, and there being no defined time limit of partnership in the aforesaid agreement dated 2/3/2020. It is a partnership at will as defined under Section 7 of the Partnership Act of 1932. As such, plaintiff number 1 has legally dissolved the partnership by legal notice dated 2/8/2020 with effect from 10 to 25 in terms of the provisions contained in Section 43 of the Indian Partnership Act. According to them, since there is no time limit fixed about the tenure of business, it is a partnership at will. If it is a partnership at will, they can terminate
Can be unilaterally terminated.
unilaterally in terms of Section 43 of the Partnership Act. And therefore, my lord, they have issued the notice on 2nd of October. And in the meantime, with 1 month's notice, they want that the partnership should be declared to be dissolved from 10/9/2025. This is their prayer. Now, Lord, will kindly have a look at the provisions of Partnership Act. Madam. First, I would like to draw your lordship's attention to Section 6 of the Partnership Act. Madam. Yes. Section 6, lordship may kindly have it. Lordship has got, madam. Section 6, mode of determining existence of partnership. In determining whether a group of persons is or is not a firm, or whether a person is or is not a partner in a firm, regard shall be had to the real intention between the parties as shown by the relevant facts taken together. Now, explanation is important. The sharing of profits or of gross returns arising from the property by persons holding a joint or common interest in that property does not by itself make such persons partners. The receipt by a person of a share of profits of a business or of payment contingent upon earning of profits or varying with the profits earned by a business does not of itself make him a partner with the persons carrying on the business, and in particular, the receipt of such share or payment by lender of money to persons engaged or about to engage in any business, by a servant or agent as remuneration, by widow or child, etc., does not by itself make the receiver a partner with the persons carrying on the business. Now, I'll make my submissions, madam. Before that, I'll just show the provisions, relevant provisions. Section 6 may kindly be seen.
Yeah, I'm on section
7, I'm sorry, 7. It says partnership at will, man. 7. Where no provision is made by the contract between the partners for the duration of their partnership or for the determination of their partnership, the partnership is partnership at will. They have mentioned in para 30. Now, lordship may see kindly section 43. Madam. Dissolution by notice of partnership at will. Where the partnership is at will, the firm may be dissolved by any partner giving notice in writing to all other partners of his intention to dissolve the firm. A firm is dissolved as from the date mentioned in the notice as the date of dissolution, or if no date is so mentioned, as from the date of the communication of the notice. So this is the manner in which a partnership at will is dissolved. Now, till now, my lord, we have not filed our written statement, we have not taken any stand, but I am assailing the order on the ground that if this is a partnership firm, assuming what you are saying is correct, and the agreement which was executed between the parties has resulted into a partnership business, then you have said in your notice and in the plaint also that you want a declaration that the business, the installations there, the land on which it exists, be declared to be your asset once again.
How's partnership defined? Let us see.
Partnership is defined in section 4. Partnership is the relationship between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. Persons who have entered into partnership with one another are called individually partners and collectively a firm, and the name under which their business is carried on is called a firm name. My lord,
Business carried on by one acting for all. That is the crux.
Yes.
Therefore, this explanation has been given.
Yes.
Mere sharing of profit may not sufficient.
May not be sufficient to determine whether
constitute
it's a
a
partnership
partnership.
business or not. Now, my lord, what is important here is this has been filed basically for a declaration. Number one, my lord, since there is a provision, my lord, in section 69, which says that if there is if the partnership is not registered, then your lordship is aware, for enforcement of any of the terms of the agreement between the parties, no suit will lie.
Between the
Partners, no suit will lie.
no suit. External, it may.
Externally, yes. Now, since they are not, they are unable to do that, they only avenue open for them is to pray for dissolution of the firm, which they have rightly done. If it is a partnership business, they can pray for dissolution of firm and rendition of accounts. Now, they are indirectly on dissolution of firm and they want accounts, but then so far as assets are concerned, the specific stand of the plaintiff in the legal notice as well as the plaint is that property should be declared to be my property. That is the stand. Now, if your lordship is
The plaintiff's property.
my lord,
The plaintiff's property.
plaintiff's property. Now, if your lordship goes to section 48 for a moment, my lord, what
48.
happens to the property that has been brought in the partnership business? Section 48.
By virtue of the agreement, the
My lord.
property
Becomes a
no, the property of the but the agreement was a property of the
plaintiff.
plaintiff.
Yeah.
It was they entered into an agreement. Whether
Yes.
that agreement is a partnership, that is one issue.
That is
right?
one. Assuming well, their stand is that it is a partnership business, so I have terminated in terms of section 43 because it is a partnership at will. It is their specific stand. If it is a partnership at will, what happens to the property? Lordship will see section 48. 48, madam. Mode of settlement of accounts between the partners. Lordship has got, madam.
Yes.
In settling the accounts of a firm after dissolution, following rules shall, subject to the agreement by the partners, be observed. Losses, including deficiencies of capital, shall be paid first out of the profits, next out of capital, and lastly, if necessary, by the partners individually in the proportions in which they were entitled to share profits. B. The assets of the firm, including any sums contributed by the partners to make the deficiencies of capital, shall be applied in the following manner. 1. In paying the debts of the firm to the third parties. In paying to each partner rateably what is the due to him from the firm for advances as distinguished from the capital. 3. In paying to each partner rateably what is due to him on account of capital. And lastly, this is important, number 4. The residue, if any, shall be divided among the partners in the proportions in which they were entitled to share profits. And the reason is, whatever property is brought in the partnership business, that from that date, it becomes the property of the partnership firm.
If
And
it is a partnership,
yes, if there is a partnership. And on dissolution,
that has to be shared also.
that has to be shared. In the ratio, you have to share the profit of the firm of business. That is the law, my lord. Now, if that is the law, my lord, the plaint prayer that kindly declare that I am owner of the land, kindly declare that I am owner of all the installations, and from tomorrow I want my son to take over, cannot be decreed, my lord. Even assuming that there was no debt to be repaid, the property has to be divided between the two persons in equal share, 50-50, my lord, because profit
So it
sharing.
started as a property of the plaintiff.
But the plaintiff has filed the suit thinking that it belongs to her still. On the one hand, they are saying it's a partnership business and I'm dissolving the partner in terms of section 43 of the
The partnership, then it could create complications.
Yes. My lord, this is one aspect of the matter. Second is, now we are yet to take a stand before the trial court. We have not filed our reply, etc. Supposing, my lord, ultimately the court comes to a position, depending on the stand we take, that it was not a partnership business. Then, my lord, in my humble submission, it will be a contract. There is a contract between the parties, my lord. There is an agreement. If your lordship kindly goes to the Contract Act,
Taken up.
and if your lordship finds that under the agreement, there is a provision permitting or allowing the defendant to run the business, then it is an agency, my lord, in terms of section 182 of the Contract Act.
Then it will be, we have to go by the law of termination of agency.
Yes, madam. Absolutely, madam. Section 182 of the Contract Act provides agent and principal defined. An agent is a person employed to do any act for another or to represent another in dealings with the third person. The person for whom such act is done or who is so represented is called the principal. Now, if the plaintiff thinks, no, I still continue to be the owner of the property and you have only been appointed as an agent of mine to act on my behalf to carry on the business and give me a share of profit, then it is an agency in terms of section 182 of the Contract Act. Now, if it is an agency, what happens as a consequence, my lord, your lordship will find at section 201, termination, which your lordship has just now said, my lord. How it is to be terminated, section 201 of the Contract Act. Termination of agency. An agency is terminated by the principal revoking his authority, or by the agent renouncing the business of the agency, or by the business of the agency being completed, or by either the principal or agent dying or becoming of unsound mind, or by the principal being adjudicated and insolvent under the provisions of any act for the time being in force for the relief of insolvent debtors. Important, my lord. Termination of agency where agent has an interest in subject matter, where the agent has himself an interest in the property which forms the subject matter of the agency cannot, in the absence of an express contract, be terminated to the prejudice of such interest. Meaning thereby that if the agent, defendant has an interest in the business and the agreement itself provides that I will invest for the purpose of repairing the installations to make it a running condition business, and then I'll share a profit of 50% from the profits of the business. This being the position, my lord, there is.
Then it requires an express contract.
Yes.
Like this
In the-
one,
Yes,
they had a contract.
they had a contract and I have, my lord, undoubtedly an interest in the business. My lord, I am interested in the business. That is why I have come to invest. I have invested, I have started the business, and as of now, my lord,
No, does it mean that such a contract, then suppose the principal wants to terminate such a contract
My lord.
where there is an interest, then what is the way out then? Cannot in the absence of a express contract.
yes, it says the
The
agency
interpretation
cannot,
is-
in the absence, if there is a clearly something in the contract that see it will be terminated under such and such conditions, then matter is different. Otherwise, it cannot be terminated to the prejudice of such interest. My lord, that is why trial is necessary. At the end of the trial, if the plaintiff succeeds in proving that I have violated, or if I succeed in showing that no, you have started demanding more money than your share since you have found that it has become a good business and you want your son to take over by removing me, whether that can be allowed or not. So there are contra cases, my lord. Plaintiff has his own case, defendant has his own case. And at the end of the trial, it has to be decided either way it goes. Now, my lord, in this,
The absence of an express contract, that means the contract itself should provide that
should-
there's an agency and he might have an interest in the agency, but so and so grounds, it can be terminated to the express contract.
yes, my submission will be, as far as termination is concerned, in the absence of any express contract, it says it cannot be terminated to the prejudice of such interest. If I have an interest, and even if I have an interest, if there is something expressly provided in the contract that says, even if you have an interest,
That's what I'm saying.
if a particular
what I'm saying.
contingency arises,
That
it
is
will be
what-
terminated.
that
That's
is the
what
correct
your lord-
interpretation.
Yes, madam,
Yes.
absolutely
Anyway.
correct. Absolutely correct, madam. Now, my lord, question is, my lord, in this background and in these different aspects involved in this case, whether there should have been a temporary injunction to restrain the defendant. Because either way, my lord, in a suit where you have your ultimate prayer is that you should become the owner of the business now. If it is a partnership business, apparently you have accepted that it is a partnership business. Property is no longer your property. It has become the property of the farm. You ultimately change your stand, amend your plaint, you say that no, it's only a permission I've given. It is only an agency in terms of the Contract Act. Even then, you cannot terminate. Yes, at the end of the trial, if you can make out some sort of a case saying that even if there is no provision in the agreement, but we cannot allow you to continue further, then matter is different, my lord. Subject to what the defendant says, what kind of evidence is led in the trial of the suit. But question is, in this background, whether the defendant who has definitely interest in the business can be straightway, my lord, dislodged from the business, saying that I want to induct my son to have the ownership of the business, he will turn. That is the whole purpose. And if you go to the written statement, my lord, I can show that they have been demanding more money when they have realized. And the reply also, we have taken the same stand. When the plaintiff has realized that it has become a good business, it is better to take over and drive out the defendant, whether that is permissible under the law. And as I have stated in the beginning, my lord, if there is no prayer for mandatory injunction, the question of granting temporary injunction, even otherwise doesn't arise. And that is the ground on which I am challenging, my lord. My lord, there are two, three, just one small paragraph I am relying on. There is one is old judgment of 1998, 1 GLR, page 383.
Supreme Court judgment will also
My
be
lord, this is of our High Court, my lord. Like this. 81 GLR 383. Para 4, my lord. What will go, para 4. Next, coming to the question regarding order, it is so in miscase number so that was an order of maintenance of status quo, making the earlier order of injunction absolute. It may be stated here in that no such prayer was made in the plaint by the plaintiff. Only 3 prayers were made in the plaint, but without praying for an injunction, an order of maintenance of status quo was granted. It is well settled that without making a prayer for permanent injunction, no temporary injunction can be granted. When a permanent injunction was not sought for, the question of granting temporary injunction does not arise. But this judgment was referred with approval in a very recent judgment reported in
There would be some more, the foundational judgment of Supreme Court on
well,
this,
I'm
on
coming,
this principle.
I'm coming to that.
Anyway, but we can
Yes,
use this also.
But this has been referred in a recent judgment of 2018, which is, my lord, you will find the Honorable Justice Surana judgment. There, this judgment has been relied on in para 16. I'll not trouble your lordship much, my lord. This is possibly is a settled law.
We are calling for the scan record, at least. Calling for the record, right? We have to call for the record.
Records may not be necessary, my lord. This is a mere matter of.
You'll need some. Yes.
But two more judgments are there, if I may cite.
Yes. I'll turn on the microphone.
Then your lordship will find there's one judgment of 1983 4 SSC 625.
Cotton Corporation.
On the proposition that by an interim relief, if final relief cannot be granted, because their ultimate prayer is to that I should go out from the business. There are 10, my lord, only one paragraph I am reading. There are 10 lordships got.
Which one?
1983 4 SSC 625 Cotton Corporation of India Limited versus para 10, my lord. Mr. So-and-so Land Council for the respondent bank contended that section 441B is not at all attracted because it deals with perpetual injunction and the temporary or interim injunction is regulated by Code of Civil Procedure specially so provided in section 37 of the Act. Expression injunction in section 41B is not qualified by any adjective, therefore, it would comprehend both interim and perpetual injunction. It is, however, true that section 37 specifically provides that temporary injunction which have to be continue until a specified time or until further order of the court are regulated by the CPC. But if a dichotomy is introduced by confining section 41 to perpetual injunction only, section 37 read with order 39 of the Code of Civil Procedure confined to a temporary injunction, and unnecessary gray area will develop. Well, we are not concerned very much with that. Now, this is important. It is indisputable that temporary injunction is granted during the pendency of the proceedings so that while granting final relief, the court is not faced with a situation that the relief becomes infructuous or that during pendency of the proceeding an unfair advantage is not taken by the party in default or against whom temporary injunction is sought. But power to grant temporary injunction was conferred in aid or as auxiliary to the final relief that may be granted. If the final relief cannot be granted in terms as prayed for, temporary relief in the same terms can hardly, if ever, be granted. State of Orissa versus so-and-so, a constitutional bench of this court clearly spelled out the contours within which interim relief can be granted. The court said that an interim relief can be granted only in aid of an as ancillary to main relief which may be available to the party on final determination of rights in a suit or proceeding. If this be the purpose to achieve which power to grant temporary relief is concerned, it is inconceivable that where the final relief cannot be granted in terms sought for, because the statute bars granting such relief ipso facto temporary relief on the same nature cannot be granted. So only for that matter I am referring to the judgment. Then my lord, one important judgment is there, 2004 4 SSC page 697.
Okay.
2004 4 SSC page 697. Para 11 and 12. My lord, 11 I will be reading only portion of the paragraph. Page 703, my lord, on top the concluding part of para 11 is there. I am reading from there. Page 703. On top, my lord, as the conclusion of hearing on merits is likely to take some time, the parties press for interim relief being granted in interregnum. An order of interim relief may or may not be a reasoned one, but the factors of prima facie case, irreparable injury, and balance of convenience do work at the back of the mind of the one who passes an order of interim nature. Ordinarily, the court is inclined to maintain status quo as obtaining on the date of commencement of the proceedings. However, there are a few cases which call for the court's leaning not in favor of maintaining the status quo, and lesser in percentage are the cases when an order tantamounting to a mandamus is required to be issued, even at an interim stage. There are matters of significance and of moment posing themselves as moment of truth. Such cases do cause dilemma and put the wits of any judge to test. Situations emerge where the granting of an interim relief would tantamount to granting the final relief itself. And then there may be converse cases where withholding of an interim relief would tantamount to dismissal of the main petition itself. For by the time the main matter comes up for hearing, there would be nothing left to be allowed as relief to the petitioner, though all the findings may be in his favor. In such a case, the availability of a very strong prima facie case of a standard much higher than just prima facie case, the considerations of balance of convenience and irreparable injury, forcefully tilting the balance of the case totally in favor of the applicant, may persuade the court to grant an interim relief, though it amounts to granting the final relief itself. Of course, such would be rare and exceptional cases. The court would grant such an interim relief only if satisfied that withholding of it pique the conscience of the court and do violence to the sense of justice, resulting in injustice being perpetuated throughout the hearing. And at the end, the court would not be able to vindicate the cause of justice. Obviously, such would be rare cases accompanied by compelling circumstances where the injury complained of is immediate and pressing and would cause extreme hardship. The conduct of the parties shall also have to be seen, and the court may put the parties on such terms as may be prudent. Lordship has seen, my lord, what was necessary for the learned trial court is to weigh, my lord, as to what will happen if the final relief, although it amounts to final relief, is not granted to the plaintiff. Here is a case, my lord, where if the final relief of stopping the business is granted, then I will be suffering, whereas the plaintiff will not suffer. And in the case, my lord, the defendant is allowed to, my lord, continue with the business by refusing interim injunction. And lastly, when it says by putting them into such terms, maybe a term could have been, condition could have been imposed saying that now on whatever business you do, because her complaint is that I did not give her share. Now on whatever business you do, keep an accounts, show us before the court so that we can ultimately share in the ratio of 50:50. That should have been the order to maintain the status quo. Now, giving an order of restraining the conduct of the business as a whole would amount to giving the final relief. Just last one judgment, my lord. 1966, Air 66 Supreme Court 1300. Air 66 page 130. That there is no pagination also. And para 7, your lordship kindly turns to. Just one paragraph I'll read.
Page.
The pagination is also.
Pages.
It will be possibly fourth page, para 7.
Para 7.
7. Just the top part I'll read, madam. It seems to us that looking to the scheme of the Indian Act, no other view can reasonably be taken. The whole concept of partnership is to embark upon a joint venture and for that purpose to bring in as capital money or even property, including immovable property. Once that is done, whatever is brought in would cease to be the trading asset of the person who brought it in. It would be the trading asset of the partnership in which all partners would have interest in proportion to their share in the joint venture of the business of the partnership. The person who brought it in would therefore not be able to claim or exercise any exclusive right over any such property which he has brought in, much less over any other partnership property. He would not be able to exercise his right even to the extent of his share in the business of the partnership. As already stated, his right during the subsistence of the partnership is to get his share of profits from time to time as may be agreed upon amongst the partners, and after dissolution, this is important, of the partnership or with his retirement from the partnership of the value of his share in the net partnership assets as on the date of dissolution or retirement after deduction of liabilities and prior charges. So whatever property was brought in, even according to the stand they have taken in the legal notice as well as the plaint, they are entitled to only share of the property after the dissolution. But their whole purpose of bringing the suit and praying for an injunction is to drive me out, get the property back, and decree of declaration that they are entitled to run the business.
In the agency, if it is an agency.
And if it is an agency, my lord, first of all, the termination of agency itself is bad. Either way, my lord, they are not entitled to an order of temporary injunction restraining me from conducting the business. Yes, as the Honorable Supreme Court said, in such cases, I should be put to terms that if a temporary injunction is given, that I should maintain the account so that at the end of the day, I do not deprive her of her share of profit in terms of the agreement. That way, my lord, my submission before Lordship is the order is bad in law. The Lordship will kindly admit the appeal and stay the operation so that the business runs with condition which your Lordship can always put in terms of the judgment, that I will maintain the accounts, maybe I'll produce it before the court below. Otherwise, business should not be stopped. I have invested, now suddenly by a temporary ex parte injunction, I've been asked to leave it. That's my submission.
With regard to respond number 1, R1, caveat has to be discharged, and 2 and 3 are represented. Right. Appeal can be admitted, of course. The appeal has to be admitted. We'll call for the scan copy of the.
Yes, ma'am.
Since this is a challenge to the ex parte injunction, this proceeding should not linger for long.
On 24th, it is fixed, your lordship, otherwise. File the objection, then on 24th, we can. Kindly,
Are you ready to argue today?
some aspects I want to point out. Let me kindly come to the
Is the agreement?
agreement your lordship have already used. So I'll clause 2. Yep. And is mine. I am the owner. A breach. But after, in terms of this agreement, what happened, the first party and the second party shall bear all the necessary expense to repair, only repair, your lordship, the said way bridge equally. So both of. Thereafter, the second party shall be at liberty to appoint employees for running. Now, fifth clause is that it from the said business shall be distributed between the first party and the second party, so 50-50. And the time limit set here. Pay out that if there is any dispute, and it is subject to the jurisdiction of the one appeal. Agreement itself, it transpires, your lordship, that his share in this agreement is limited only a bridge, to the repair of the way bridge. That was his only investment. That repaired it, and we had also paid half of the amount.
50% of the profits.
And
50%
thereafter, whatever profits were coming, 50%, it was to be divided 50-50. What happened, your lordship? at page 51, I have clearly stated that this is my legal notice to him.
This we have gone through.
On through at paragraph 5, I have stated my grievance that you are not disclosing the actual monthly income of the said weighbridge business. As per his whims and caprices, whenever he deems gives me something. This is going on since some time. I have issued this notice in the month of August 25. Thereafter, I notified him at paragraph 8 that from 10/9/2025, I am going to close down the business. He has replied saying that at legal notice reply, your lordship will find at page 55, last part he says that my client is always ready to settle the matter with utmost. That even my client shall be ready to. Thereafter, what happened, your lordship? I filed the application at page 50 for the Deputy Commissioner, Gauhati Municipal Corporation. This is subject sending necessary information in the matter of closure of the aforesaid weighbridge of the present trade license. With due respect, I, the undersigned, do hereby begs to inform you that I am the sole proprietor of the aforesaid Mahalakshmi weighbridge, which is located at so-and-so, that this weighbridge is located over my plot of land, that I had closed the aforesaid Mahalakshmi 10/9/2025. Personal reasons. That, sir, it is important to mention herein. A weighbridge business was run by one Indrajit Borough on behalf of me, and my decision from 10/9/25 was duly intimated to said Mr. Borough through one registered letter bearing so-and-so dated 2/8/25. So I would like to request your good self to kindly admit this petition and my decision to surrender the above referred trade license. Further, it is to humbly inform you that I have not issued any NOC to anybody for obtaining trade license of the said weighbridge. Page 39, I have annexed the cancellation of the trade license. Your lordship will find. Page 39. The trade license for the weighbridge was also 10/10/2025. License number so-and-so, it is stamped as cancelled. The background, as on date.
But could it have been done? Because the suit was about dissolution.
Because
Suit was
the
about
moment
that.
I sent a notice to him, partnership firms to dissolve, your lordship. I have placed 2 judgments. Judgments I am
So
reading.
then only if it is a partnership.
It is a partnership, your lordship, as per
That could be a tribal issue.
lordship, but it is apparent, prima facie evidence, your lordship, from the agreement. Your lordship will see the legal agreement ingredients for a partnership. At paragraph 19, your lordship, of the judgment, please. 2011 0 Supreme 3451. Asha Agarwal versus Ravindra and Company. Paragraph 19, your lordship.
This judgment.
Paragraph 19, your lordship. This is paragraph 19.
Okay, no problem.
Paragraph 19, in view of the facts appearing in the
Just a
case-
minute. In view of the facts appearing in the face of the record.
in view of the appearing in the face of the arguments put forth by of the respective party, the primary issue before us would be whether the partner so-and-so is still in resolved on and from 26/2008, if not at the from 15/7/2008. In this connection, it would be appropriate to scrutinize the letter and also the letter of the appellant number 1. Letters of Srimati Sarita Agarwal and Ravindra Agarwal are seen to have been Asha Agarwal, the appellant number 1. Both the letters bear the date 4/7/2008. In the letters, it is indicated of the letters retired as the partner from the partnership firm Messrs. Ravindra and Co. company Kayamganj with effect from 26/2008 and also intended that the partnership firm be dissolved. Appellant number 1 by her letter refers to Range Superintendent Excise Range Kayamganj also dissociated herself as a partner from the partnership firm with effect from 15/7/2008. The aforesaid partnership firm Messrs. Ravindra and Co. with effect from 15/7 letter was accompanied by a copy of the letters written by Sri Ravindra Kumar Agarwal and Sarita Agarwal. By these letters, the partners of the partnership firm, Messrs. Ravindra and Co., retired themselves. It is already stated herein before that the partnership firm, Messrs. Ravindra and Co., had 3 partners whose names are indicated above. Therefore, on their retirement, the partnership firm, Messrs. Ravindra and Co., automatically stood dissolved. Section 4 of the Partnership Act 1932 deals with definition of partnership, partner firm, under which their business firm name, which provides as under partnership is the relation between persons who have agreed to share carried on by all of them or any of them acting for all. Persons who have entered into partnership with one another are called individually partners and collectively a firm, and the name under which their business firm name. Paragraph 20. A firm as such cannot be a member of partnership. Partnership is a relation which subsists between persons, but a firm is not a person. It is not an entity. It is merely collective name for an individuals which are members of the partnership, neither a legal entity nor as it the person. A firm name in truth is merely a cluster of individuals who form to constitute a partnership firm. There must be 3 elements. Number 1, a business. Number 2, there must be an agreement to share the profits of that business. And number 3, business must be carried on by all or any of the partners acting for all. In context above, it would be appropriate to say that Messrs. and Co. was constituted by 3 members, namely the appellant number 1 to carry on business and to share profits from the same. Since there is no indication of the carrying of the business of firm by one of them acting for all, in these circumstances, it can be said, rather held that business of the partnership firm was carried by all partners. Section 32 of the Partnership Act 1932 speaks on.
But in this case, there will be a question of, sharing of the property, which originally belonged only to you, right?
But your
The
lordship,
bridge,
your
the
lordship will
rooms.
kindly
Anyway,
see,
so, and what about 69, section 69? Anyway,
Section
we'll come to
69,
that
your
too.
lordship, what Section 48, your lordship, is not applicable because accounts, only it is in respect of the accounts, your lordship. Senior counsel has placed, and your lordship, there is another judgment, your lordship, Allahabad High Court. I just want to please complete the legal position here, your lordship, make the matters more clear. In the context above, it would be appropriate to say that Messrs. Mahindra was constituted by, I have read, your lordship, carry and to share, since there is no indication of the carrying of the business of partnership by one of them acting for all. In these circumstances, it rather held that business of partnership firm was carried by all partners. Section 32 of the Partnership Act 1932 speaks on the subject of retirement of a partner. It says that a partner may retire. C is relevant, your lordship, where the partnership is at will by giving notice in writing to all the other partners of his intention to retire. Therefore, under the 3 modes, a partner of a partnership firm may retire from the firm. Messrs. Ravindra and Co. was a partnership at will. Therefore, any of the partners of the firm can retire from the partnership by giving writing to all other partners. It was held in catena of decisions. Citations are given. By mere retirement of a partner, a firm is not dissolved, but the retiring partner must give notice of his intention to dissolve the firm in order to bring effect a dissolution. In the decision reported in AIR 1960 Madras 457, it was held that where there are only 2 persons, in our case, and one severs his relation with the business of the partnership, there is dissolution and not retirement. Section 43 also provides the procedure for dissolution by notice of partnership is as under. Where the partnership is at will, the firm may be dissolved by any partner giving notice in writing to all the other partners of his intent. Number 2, the firm is dissolved as from the date mentioned in the notice as the date of dissolution, or if no date is so mentioned, as from the date of communication of the notice. The decision reported in AIR 1976 Gauhati 12, it was held that when a partnership is at will is formed, it can come to an end by notice of dissolution or abandonment by one of the partners. If a partnership is at will and one of the partners wishes to dissolve the partnership firm and also acts in furtherance thereof by giving necessary notice, the moment said notice is issued, moment the notice received by the other party, the partnership stands dissolved. This judgment, your lordship, same parties, they had litigated before the Honorable Allahabad High Court, paragraph 26 to 33. Only your lordship again reiterating the provision, paragraph 32 and 33, your lordship. Rich F.D. Mehta versus Minu F.D. Mehta, 1970 AIR 1971 S. It was observed that where a firm consists of two partners, the
You're reading this judgment?
lordship,
Punjab, Haryana. hai.
Supreme Court, Allahabad High Court judgment. Your lordship. This is
This part of this judgment or sir, you submitted?
another round of litigation by the same Allahabad High Court.
It's you're reading from here, this one. Asha Agarwal.
The AFR court number 5.
Oh yeah, this one. no? Yeah, from Punjab, Haryana. High Court, I think. Yes, Punjab, Haryana. Yeah, para.
Lordship, paragraph 32 at page 9.
Yeah.
Relevant, I'm relying on 26 to 33. Paragraph 32 and 30. Haruch F.D. Mehta versus Minu F.D. Mehta, AIR 1971. Lordship has it. Lordship, page 9.
Yes, it's para 32.
Paragraph 32.
Yes, got it.
Haruch F.D. Mehta versus Minu F.D. Mehta, AIR. Observe that where a firm consists of two partners, the withdrawal of one will automatically result in its dissolution. Similarly, in a case of a firm consisting of more partners, if all but one withdraw, the partnership cannot continue and comes to an end. 33. In such circumstances, though the question of dissolution of the safe company or its reconstitution would be an issue to be decided on the basis of the evidence to be adduced at time of hearing, the dissolution of the firm is apparent. When if it is taken to be a case of retirement of two partners, it by necessary implication dissolution of the firm as a partnership cannot be continued by a single person, as till that time no new person or partner had been. So in my humble submission, this agreement qualifies to be a partnership. Section 4 of the Indian Partnership Act, and we have lawfully terminated the partnership, and he is for the last 6 months carrying on with the business legally, your lordship, without any trade license. And even the electricity connection was also disconnected. Now he has installed a diesel generator and running the said business in France, your lordship. And in the process, he has also occupied my land and illegally he's continuing. And regarding the section 48 submission, your lordship, 48 will come in if and the building by any means cannot be said to be by any stretch of imagination by on the agreement cannot be said to constitute the property of the partnership. Section 48 says only in respect of 48(3), the assets of the firm, 48 assets of the firm, including any sums contributed by the partners. So what is his contribution, your lordship? While repairing, he has contributed in the scale repairing, he has started the business. So in the land and the building, he doesn't have any.
No, the assets of the firm, including any sums contributed.
Any sums
including,
contributed. So he's
not only sums. In fact, the moment you say prima facie that it is a partnership, the waiver becomes.
No, your lordship. As per section 8, apparently, partnership will always be to the extent of contribution. I may contribute more, he may contribute less.
Yes. But when the
Contribution of mine
if it is dissolved, the distribution would be of the assets will come in the ratio of the sharing of profits,
Accounts
which
is,
is 50-50. right?
Lordship, that is only in respect of the income generated, the accounts. That is with him.
No, I'm saying that you look at 48B,
48
subclause 4, Roman 4. Okay, this will be decided at the trial, of course.
Lordship.
The residue, if any, shall be divided among the partners, first to the debts, then to each partner, and any residue divided in the same proportion in which they are entitled to share profits. Anyway, so
Extent of the contribution, you know. So at this stage, your Lordship may kindly not and let them file an objection on next day, your Lordship. On that day,
what is your, I would like to say, hear your submissions on the cancellation of the trade license.
Trade license is a thing. As the business concern, without the trade license is operating. I have applied for a trade license. My lord, here is a case where Lordship possibly will see whether the learned trial court has committed any error in preventing the business from being conducted. And so far as section 48(3)(b) is concerned, my lord, as your Lordship has pointed out, is very absolutely clear. The assets of the farm, it doesn't say that only you will get your share from the contribution you have made. It says assets of the farm. What are the assets of the farm? You have contributed land, you have contributed installation of the way bridge. All have become, according to you, assets of the farm. Now you are saying, no, you.
In a way, you stood to lose actually by making it a partnership.
Yes,
because the
yes.
property was yours.
Yes.
Should have been an agency actually. But anyway, so. But there is no, this point is, cannot be overlooked actually, that there is no prayer for injunction in the permanent injunction, right?
that can be corrected by way of an amendment. There is no bar.
We cannot say much also because the injunction itself is being decided,
Yes.
only ex parte. Have you filed that? You must have filed that compliance affidavit,
Compliance
right?
has been done.
That has been done.
Sub-rule 3 compliance is there, so there is no violation.
Lordship is examining whether the order is bad in law. It's absolutely bad in law from various aspects. So I'll pray the order may be stayed so that the business goes on, and your Lordship will put a condition that I'll submit all the accounts.
That is why I asked this question. I think you preempted perhaps, you know, that
One-
the outcome of, to some extent, at least the outcome of the suit, because the suit itself will be entering into those aspects.
Yes.
So when it is finally resolved, then the trade license will be automatically gone.
My
So
lord, may I submit
You proceeded to cancel the trade
just-
license.
may I make just one submission? Plaintiff is presuming that after issuing notice in terms of section 43, the partnership is dissolved. You have prayed for a decree of dissolution. If today you assume that moment I issued, it is dissolved, why are you waiting for the decree then? Don't go to the court. You have gone to the court because you want a decree from the court. If you presume that the decree is already passed, I have to execute. Dissolution, you have prayed for a decree of dissolution. Today, there is no decree. You are thinking that you have dissolved. Court is yet to decide whether it amounts to dissolution of the partnership farm or not. Because court has to pass a decree. Before a decree is passed, my lord, he is thinking that I am presuming that the decree is there. It is resolved. So from tomorrow I am in, he is out. Then nothing remains in the suit. And my contribution in the business goes. And you are still saying, my lord, I'm with all respect to my learned friend, the plaintiff is still thinking that the property continues to be my property. You have taken a stand that it is a partnership business. The land, the installations, everything has become a part of the asset of the partnership farm. This is what the Act, section 48
It is a
says.
partnership.
Yes. As your Lordship has rightly pointed out, that was a wrong stand taken by the
No,
plaintiff.
no, I
No,
have
it
no right to
appears
say
from
that.
the
but
documents, my lord. From the documents.
Seems to me that he stood
It
to
seems
lose
to be, yes.
because
Lordship, again,
by
if
calling
I
it a
pleaded
partnership.
agency-
Why give away your property?
If I would have pleaded agency. And your Lordship, if now I have. gone
Breach
for-
of contract actually.
Why I have prayed for dissolution, because
He did not give you the money properly. That is your primary grievance. Breach of contract
And
actually.
he is
Could have
occupying.
been
the-
that kindly
breach of
give my
contract.
share. Accounts, rendition of accounts and my share and maybe dissolution of
And
the farm.
despite the notice, he has not settled.
What about 69? This kind of a suit will be barred.
possibly it will not be barred because 69 says if you are enforcing any of the terms of contract of or of a partnership, then it is barred.
Otherwise,
And
it
it
will-
says, my lord, if it is for dissolution, they can.
despite the
Yes,
non
I'll not argue, my lord, unfairly that suit is
No, no.
not maintained.
we have to be correct in the
Fine.
law.
Yes, yes.
We're all officers of court. Anyway, short order. Okay. The instant order has been preferred under section order 43 rule R. And of the CPC, agreed by the order dated 24/2/2026, passed by the learned civil judge senior division number 2, Kamrup M, trial court in Ms. J case number 197 of 2026, arising out of title suit number 104 of 2026. By the said impugned order, the learned trial court was pleased to pass an order of ex parte temporary injunction restraining the defendant petitioner from running the business of the Way Bridge in the name and style of MS Mahalakshmi Way Bridge. The facts in a nutshell may be stated. The plaintiff hearing, the plaintiff respondent, the plaintiff respondent / respondent one, entered into an agreement with the petitioner defendant, whereby under certain terms and conditions, whereby the petitioner defendant was to run the Way Bridge, aforementioned Way Bridge, and full stop. As per the terms and conditions, they were to share the expenses and also the profits in the ratio of 50-50. Subsequently, on the purported ground that the petitioner not comply with the terms of the agreement in making payments, etc., to the plaintiff, a legal notice dated so and so was issued, which was replied to by the petitioner defendant. Subsequently, the title suit mentioned above came to be filed, whereby the respondent number one is plaintiff, the respondent's plaintiff have sought declaration regarding dissolution of the deed of agreement dated 2/3/2020, semicolon, declaration of right title interest over the plot of land and over the machinery, etc., pertaining to the Way Bridge, semicolon, decree for eviction of the defendants, semicolon, decree for recovery and delivery of first possession. In that suit, subsequently, the application for injunction, temporary injunction was filed, giving rise to Ms. J case number 197 of 2026, which is pending adjudication and energy. And the petitioner defendant has not yet filed the objection. As already mentioned by the impugned order, para 17, the ex parte interim or ex parte temporary injunction order was passed, restraining the defendant petitioner from running that business, Weighbridge. Admittedly, the petitioner was running the Weighbridge pursuant to the agreement. So, for the petition, as per the respondent, ran into difficulties due to violation of its terms. Learned senior counsel appearing for the petitioner, it's that the order is bad in law because in the title suit, there is no prayer for permanent injunction. Of the same, no order pertaining to interim injunction. Interim temporary injunction could have been the question as to whether the agreement between the parties constitute a partnership and the terms on which whether it came to be dissolved as contended by the respondent plaintiff in matters of adjudication during the trial. It is also submitted by the learned counsel. If the agreement is taken to be one creating an agency, then its termination would proceed as per relevant portions of the Contract Act. And that the same would also be during the trial. On the other hand, the learned counsel for the caveat has been filed on behalf of on behalf of this one number 1, and learned counsel appears for the caveat. The caveat stands discharged. Learned counsel also enters appearance on behalf of the respondent number 2. Learned counsel for the submits that terms of 48 of the a tenant at will, section 48, right? That will partnership can the partnership at will can be terminated by giving a notice at the date indicated.
43.
43. Then we'll cross check it. Don't want to make it very long. And the date indicated, it notice constitute dissolution of the firm. They submitted that here's the plaintiff respondent has already proceeded for cancellation of the trade license, and same has been cancelled also. The appeal is admitted for here. Call for the scanned case record of only the miscase would do, right? Miscase can is there actually. And TCR of misj case number 197 of 26 on the learned court below, learned trial court, civil judge senior division number 2. Upon perusing the prayer portion of the suit, though there are 4 specific reliefs have been claimed and 1 generic relief. However, there is no specific relief regarding permanent injunction. Further, as the petitioner defendant was admittedly running the business at the time of institution of the suit, the order of ex parte injunction would definitely have the effect of stopping his running of the business as was directed by the said order. Full stop. It is well settled that ex parte interim, ex parte temporary injunction would be justified when the property would be subject to serious compromise or prejudice unless an order of injunction is passed expeditiously. Full stop. That you need for extra copies of this, extra copies of the petition. Learned counsel has learned counsel for the respondents has received the copies. Stop. In the given facts and circumstances and in the backdrop of the aforesaid narration and discussion, till the returnable date, the impugned order shall remain stay till the returnable date. However, you are suggesting, however, he will maintain accounts.
Yes.
However, the defendant who was running the weighbridge shall maintain proper accounts of the same and submit the same for the court. And we'll dispose it of. Otherwise, that will be decided before this remains pending. You let the TCR come. TCR will be necessary, but it's a process actually. It will take a while, but TCR, if we call for the TCR, we've called for the TCR. Take some time. List out. Can TCR. Because they are very overloaded now. Administrative side.
There will go on.
No. Yeah, injunction proceeding, let it go on. He's only challenging the ex parte.
Yes, ma'am.
Ex parte is under stay. That means there is as if there is no ex parte order.
Yes.
Injunction will be decided. That's why we cannot write more. Actually.
May I submit one thing?
Yes.
If this order possibly subject to what my learned friend says, this appeal can be disposed of because ultimately we'll have to file objection and the trial court will have to decide. For the benefit of my learned friend only, because otherwise
What do you say?
I leave it to
Then
your-
instead of stay, it will be set aside.
we'll file it, but then anyway.
They will lengthen the.
Let it remain when we'll file objection, trial court will proceed.
Then we'll see.
Yes.
We should say list it after 3 weeks.
4 weeks.
4 weeks. Okay.
Right.
4 weeks. Yeah, take a date, please. You suggested it mutually. Week after Bihu or thereafter? 29/4. 4/4.
29. Right. Lord.
The next matter. 14 you can give in the meantime. You can 14 you can give. Come. Just a short break.
The issue. Where the petitioners agree by the award amount. Enhancement. Judgment is at paid 18.
No, heard case I have learned counsel. Not admitted, right?
Not admitted, but first time.
No, another order is there.
One order is there where we wanted an amendment because there was a review application. So court allowed, we incorporated only that parameter.
Appeal has been filed of the MV Act 1988 against or dated Act 2020. 732 of 2017. That learned MACT number 3, MACT for enhancement.
Quantum was quite less. They
To
have only.
the insurance companies, the insurance insurer has been treated as respondent number 1 and 2. Both are ICSA number.
Pilot.
Both, there are two vehicles.
No, one vehicle.
No, both 1 and 2, both are ICSA number. Okay,
Sir,
the other branch.
Branch.
Mid the IP. And the issue notice. Speed post. Call for the original TCR of it. MSC case number so and so.
Well, perhaps until case report will not be required because we will be filing an execution application there. They might require this. If required, will
Since it is disposed of. So
no, because
10 copy.
10 copies.
10 copies. 10 TC. Just after 4 weeks. I registered.
Grateful.
I felt as if I'm in Jorhat again.
So nice open. 16.
The appeal, madam. Claim petition was dismissed, my lord, for want of jurisdiction, my lord, territorial jurisdiction. And took place within the, my lord, Buxar district, and insurance company has its office in Gauhati. But the claim petition, my lord, was filed in Borpeta district. That is why, my lord, but the opposite party, my lord, never raised the question. But one issue was framed, and that issue was decided against the claimant. So my humble
There is a
submission.
short judgment.
Yes, my lord.
Forgotten the name.
Yes.
Which discusses this territorial jurisdiction because the MACT has so many limbs.
So many, yes.
So many limbs. If
So-
any of the limb is there, then jurisdiction will be there.
Yes. Well, the beneficial legislation, my lord. So-
Borpeta, there is no branch of that insurance company.
No, my lord.
There is no insurer. Liberty
Borpeta,
General,
there are no
they may
branch
not
of
have.
this.
Yes. Okay.
In one judgment, my lord, there was 2016 judgment.
Admitted.
Yes.
Mr. Polita, Learned Counsel. 73. Impugn judgment and impugn judgment dated 4/12/2025 by learned member MSc Borpeta MSc 20, whereby the claim petition of the appellants were dismissed on the ground of lack of territorial jurisdiction. Admit notice upon the respondents. Call original TCR, we can call in this case, original TCR of MSc case number. List after 4 weeks on a date to be fixed by registrar.
All right.
Please, my lord.
Admit and issue notice, edit.
Protection may be given, my lord. My lord, in this
Then
case,
we'll have to delve into it a little bit. We have to enter.
take a few minutes of this honorable court. My lord, I'll just give a
Going
technical
slow today.
metrics of the case, my lord. Very brief, my lord. What had happened is this, in study absolute owner.
Take the microphone, please.
May it please.
Yeah, better.
May it please, my lord.
Yes.
Property which is located in the Schedule A property, my lord. Now, what happened is that, my lord, promoter, my lord, what he did is that he had allegedly taken some loan
and had mortgaged the entire Schedule A land where our Schedule B property, the flat, is situated. My lord, what happened is that we were not aware of it. We came to know about the entire situation, my lord, on 8/1/26, my lord, through an impugned notice, which my lord would have at page 109, my lord. My lord has page 109 for a moment.
You are the plaintiffs?
I am the, yes, my lord. Yes, my lord.
Possession notice.
Possession notice, but this is only with regard, this is with regard to the Schedule A property, my lord. This was issued to the respondent number 2, that is one Mr. Alauddin. Because, my lord, we were not a privy to loan, my lord. My lord may kindly appreciate the fact we didn't know about the whereabout about the entire loan. My lord, what has happened is that this came as an utter shock to us. Because 13(4) notice of the DRT, if my lord kindly has the DRT Act for a moment, or other, I can just spell it out, talks about symbolic possession, that they have taken possession of the property. And basically they have told that nobody can deal with that property where we are located. So that technically belongs to the bank now. My lord, in this case, my lord, we had filed the title suit along with the miss case. My lord, the impugned order is at page number, my lord, 158, my lord. The 9/3/26. 26 order, if my lord has.
You must have, in your plaint, you must have addressed the issue of the bar of 34.
Yes, there
Right?
I had issued. Thereafter, my lord, I had also placed on judgment passed by the Honorable Supreme Court, Central Bank of India versus
Prabhajan.
Prabhajan. Yes, my lord, in that case, my lord, I'll also hand over this, my lord. Case, my lord, it was observed by the Honorable Court that in view of the summary nature of remedy provided before DRT, and thus if certain inquiries beyond the contours of what DRT does are envisaged, a civil court remedy may be considered. My lord, we had exhausted our
Purely for fraud.
yes, we had already exhausted our remedy before DRT, although DRT didn't protect us, my lord. That order is also there, my lord, at page 128. We have filed the IA along with the main essay, my lord, securitization.
So what did they say? Let us see. Can we see the impugned order?
Yes, my lord. The impugned order, my lord, would have at page.
The injunction was refused.
That injunction was refused. I'll spell out the grounds also, my lord. Page 158 onwards, my lord, of my petition, my lord. 158. My lord may kindly have page 160, paragraph number 8 of the order.
You had appeared before the DRT also.
Yes, my lord. There also, my lord, I was not protected.
Because what a little I know, on 34 notice, 34 bar is strong bar. It's a powerful
Strong bar. We exhausted that remedy.
Only as I said, as we discussed, fraud is one of the reasons.
Yes,
but then
Prabhajan covers me, my lord. Prabhajan covers me. And there is one more. I'll just.
You cannot circumvent actually.
Yes, that is I'm a miserable person in this entire situation who was not involved with the loans and nothing. But now I am in this soup, my lord. I have landed in this soup. My lord may kindly have paragraph number 8, my lord, of the said impugned order. Page 150, page 150, 60, sorry, my 160. 60, kindly, my lord. May I read, my lord?
116?
Yes, my lord.
116.
160, my lord.
160.
That is
the DRT order.
No, my lord. This is why I've come against this order, my lord. The injunction order. This is the order passed by the learned judge below, my lord. Learned civil judge 2, my lord. 9/3/26 order. Against which I have come before this honorable. 160, my lord. Paragraph number 8. May I read, my lord?
Yes.
In the meantime, it reveals from the case record that the defendant number 2 has earlier filed a suit against the defendant number 3, that is the bank. Defendant number 2 is that allowed in, my lord. Before the court of learned civil judge, senior division number 3, Kamrup Metro, wherein the learned court was pleased to pass an order of ad interim injunction in favor of the plaintiff, restraining the OP bank from taking any coercive action in respect of taking possession of the suit land or flat. Now, my lord, this order which the learned judge had referred to
This is on a separate footing, my lord. If my lord, I will take my lord to that order also at page 114 of my petition, my lord. That was a part of the suit also, in fact. 114, my lord has.
Against the DRT, if the DRT does not give you relief, I think you can file a writ petition for this.
Yes, my lord.
Anyway.
Subject to corrections, my lord.
No, so let's proceed.
My
Next,
lord, actually,
which
this-
page should I go next?
114, my lord. The observation which was made by the learned judge, my lord, in the 9026 order is with regards to this order. This 22-12-25.
Which according to you is on a separate footing.
Separate footing, Mr. Alauddin had approached the court saying that the loan documents in question were forged. So they got a protection on a different footing. They are protected by the law with regard to the Schedule A property, but there is no mention about our Schedule B property, the Schedule B property of which I am the absolute owner. Now, my lord, my submission before this honorable, perhaps the learned court below has erred in law while observing that there is already a stay. Yes, my lord, there is a stay with regard to the Schedule A property, but nowhere it is mentioned categorically that my Schedule B property is protected, my lord, when I am residing. So tomorrow, my lord, bank has the authority and can uproot us from there. That is our grievance, my lord. That is our misery, my lord. Because, my lord, that order, my lord, this 22-12-25 order, which this Mr. Alauddin had taken, is protected. I am not protected.
Well, we have to go through this impugn order once.
Yes, my lord. In order, my lord, 158.
58 is. You prayed for interim order.
Yes,
Interim order, which was refused.
Sanction, my lord, with regard to the Schedule B property.
Because that issue, because the suit, the maintainability of the suit is also open, I think, the question, because, because the thing is that all proceedings, when reposition notice is issued, the bar of 34 per se comes into the play, right? And you have to, of course, the person can ventilate his or her grievances, but before the DRT. And the DRT, you have been to the DRT, DRT is refused. Against DRT, we know it's under 227, you file a writ petition, right? That remedy is there. But the suit has been filed, because as you know, if there is cloud on the issue of maintainability, injunction cannot be passed. But in any case, this is an ex parte injunction. Parte injunction. I think I will not be inclined to, we can,
Last humble submission.
you can make your submission.
Lord, may kindly have page 161, my lord, the last portion, my lord.
Your injunction prayer before even in the suit, your prayer for injunction has not been refused. It is pending
refused,
adjudication.
It has not been
You
given.
sought an immediate ex parte injunction so that you think the property may be lost.
Property will be lost, my lord.
But that straight remedy was there from the DRT order.
DRT remedy
Anyway,
already exhausted.
yeah, what is
DRT was not inclined, my lord.
No. Against DRT, you can challenge.
My lord, the DRT is also there.
That's
Kindly, my
no,
lord.
writ petitions also like.
But the
Anyway.
golden principle which the judges observed, my lord, the last portion of page 161, the learned judge here has observed that bank needs to be heard first before passing any operative order against such bank. Any ex parte order, if today passed against 50 number 3 bank, may cause much of difficulties and loss to the bank. My lord, the golden principle has been applied here.
No, but
Balance of convenience, irreparable injury, and prima facie case. My lord, may I kindly submit one judgment, my lord, of the honor.
what is the others injunction order? What was it? Was proceeded on what? I have not read
That
that.
was, my lord, that is at page, my lord, 114.
14, yes. I have
That
to read
was
that
filed
also then.
on the ground that the loan documents in question were forged documents, were forged by the bank, and on that ground, the learned judge had passed the ad interim order, my lord. 114 and 119 is relevant, my lord.
In the defendant number 1, is this allowed in?
Here, in this my case, my lord,
Yes.
is the 2, yes, 1 and 2 is he only, my lord. The partnership firm, 1 is the partnership firm and 2 is.
Let me just flip through this order.
Right. Okay.
This other injunction order, that the court made a determination. There was materials, to regarding fraud. According to this Prabha Jain, it passed that order. But in this case, that question also. Yes, which judgment?
My lord, the Dalpat Kumar
Dalpat
judgment
Kumar.
also, if my lord has paragraph 4, my lord, the second page. Paragraph. If I may read, my lord. May I read, my lord? Order 39, Rule 1C provides that temporary injunction may be granted where, in any suit, it is proved by the affidavit or otherwise that the defendant threatens to dispossess the plaintiff or otherwise cause injury to the plaintiff in relation to any property in dispute in the suit. The court may by order grant the temporary injunction to restrain such act or make such other order for the purpose of staying and preventing or dispossessing the plaintiff or otherwise causing injury to the plaintiff in relation to any property in dispute. The suit, as the court thinks fit, until the disposal of the suit. That is our limited prayer, my lord. My lord, tomorrow, if suppose, my lord, we are wrong, the interim order can any day be vacated, my lord. There is a provision under Order 39 in that also content. That is my humble prayer. Today, my lord, we will be protected, my lord. I am, in fact, a miserable widow also, my lord. I don't have any other shelter, my lord. That my lord
But the thing is
Prabhajan
that,
also says,
no,
my lord.
legally, you should not be on,
Yes, my lord.
wrong territory, because the maintainability aspect has to be seen. Because in the suit, in the suit, in this suit, which gave rise to this, what have you pleaded?
My lord, these are my grounds.
Have you alleged fraud?
Fraud, my lord, fraud upon, my lord, we were, my lord, fraud per se, we have not alleged upon any. There, my lord, we have pleaded that we were not aware about the said loan, my lord. Loan in context out of which the entire controversy has arisen, my lord. That we were not even a previous loan, my lord, and we were not aware, my lord. We were taken by surprise when that 8126 notice was affixed on the building of our building.
Anyway, so what I propose to do is that somehow I am not very inclined to, just state, give a short date, you take steps by speed post as well as Dusty. Let them come. Then you take.
Then, my lord, interim steps to Dusty, my lord. Till then,
You
only,
take
my lord.
Dusty, but I am not, because the issue of maintainability is because 34 bar has to be negotiated. Otherwise, we'll be in very wrong territory legally. Anyway, so very short that you just serve them, let them come.
Just one last submission, my lord.
Yes.
My lord, that aspect only. When the learned single judge, while passing that order dated 9/3/20, has observed that there is already a stay, but there is no stay with regard our Schedule B property. There is a blanket
That
stay
I can
of
observe.
Schedule A. Yes, my lord. That is a
Definitely, I'll observe.
my lord. We are not protected, my lord. That is a big error in law. Tomorrow, my lord, bank may uproot us any day, my lord. Bank people are coming.
See, the thing that I'm certainly not, I have no right to cast, merit of the case. But the thing is that sometimes what has happened is that what has been seen is that the defaulters to circumvent, they try to bring in the aspect of fraud and try to circumvent this bar of 34 and delay the recovery sometimes. So therefore, this bar also has to be negotiated and seen, adjudicated whenever it comes to the civil court, and as well as if the civil court enters into it, it must have satisfaction. And as you know, the maintainability is essential for passing interim injunction, right?
One last submission, my lord. The title search report, my lord, was not done by the bank properly, my lord. Because, my lord, we are residing in the property since 2019, my lord. In fact, my lord, the Prabhajan judgment passed by the Honorable Apex Court, I have flag marked, my lord, last page, my lord, green color. There also it is stated categorically that while the banks conduct the title search report, they should be very careful. Now, my lord, if they had conducted it properly, they would have been aware before sanctioning that loan with regard to the entire Schedule A property that we were also residing. Without taking into consideration that aspect, my lord, they had mortgaged the entire Schedule A property, my lord. There we are also residing and having an absolute property. My lord, lot of infirmities, my lord. Somehow, my lord, just till the next returnable date, my lord. Short date may be given next week. Then no coercive action at least, my lord. My lord, we'll take steps to Dusty. Date may also be fixed, my lord.
Yeah, Sharma, learned counsel for the petition. Excellent. And this appeal under or CPC against the order dated 9/3/2000. Is yes, placing out of title suit pending before the learned civil judge senior division of the impugn order. So notice has been issued on the injunction application of the appellant, but the learned court below not pass any order of ex parte interim injunctions. Exceptional remediation in if the plaintiff Plaintiff is stated to have received Surface Act regarding the property, Schedule B property.
My lord, that was with regard to the Schedule A property, my lord. Where our Schedule B property is located.
Where the plaintiff appellate also stated to have been looked. It is submitted that before, though the appellant plaintiff pursued the remedy before DRT, but the DRT not pass any orders in favor of the appellant. Got to protection of the property. In the meantime, the suit was filed, and on the application for temporary injunction, Ms. J. so and so was where notice has been issued. Section 4. Ours. Including a civil suit with regard to the notice notices issued under the Surface Act. DRT. However, in terms of the settled law of exception is available largely in case of fraudulent transactions. To the decision of Central Bank of India, Prabhat. Also another judgment, Dalpat Kumar and Prahlad Singh. Generally on the issue of orders. Trial court of the issue of whereupon notices have been issued as respondent therein. At this stage, trying to stay the impugn order to the extent of it refusing or not granting any ex parte order. However, the will be admitted for hearing and is accordingly steps of notice upon the response side by speed post as well as by Dusty and sub affidavit. Call for the scanned copy of case record of MG number 94 of 2026 in bracket in connection with TS number 147. This is the matter after 3 weeks.
It will become infructuous. 7/4 is the next date, my lord.
And 4 before that.
My lord, next week, any date. I'll take steps by Dusty, man.
And 4 it had let it be before. That you pursue on your own.
Next week, any date, my lord. Thursday, Friday, anything. I'll take Dusty. I'll find.
If 7 is if 2 clear weeks are there, two full weeks are there.
Next week, any date, my lord. I'll take steps, my lord, by Dusty only.
Let it be on 30. It's like almost 1 week only.
If Lordship permits me,
Quickly open.
next the item, we had actually mentioned the matter. I can understand the paucity of time.
And slow.
What is full? It's on a quite different point though. It's a first appeal.
Item?
Item 54, the next item actually. A different point. Although we have filed in first appeal against an ex parte ad interim injunction being given, the defendant is filed. The issue raised is quite different and has been settled by the Honorable Apex Court in such cases. So, my lord,
Next week, you take it.
Monday, if lordship permits me, not because we'll be difficult. Monday with a prayer to upgrade, my lord. But that's a request, my lord, because we had waited. We had that much, if lordship permits me. Monday,
Read it in the course of the.
I'll make a mention to the lordship.
May I pray, your lord? Item number 20, your lord. Kindly be taken up next week.
Otherwise, it will be, dates will be given, will be leftovers. Item 20,
Yes, your lord.
RSA. This hearing was supposed to be conducted. When?
Next week, your lord.
I mentioned item
61 load. MSAP release of the amount, lordship. So 24th, lordship.
Take the dates from him.
I mentioned item 18.
Yes, mention it.
Yeah.
Those are, acha, it's a AB. Bills of, yeah.
Maybe continue. The CD, today it was fixed for calling of CD. The CD haven't.
Ask my lord whether the my lord. But my lord, we gave a my lord. But my lord, Sarsit is something.
Interim
Open in.
extend
Part of.
it is extended. Tuesday can be on.
17 lordship, bail hearing matter lordship. Petitioner behind was more than lordship, 3 years, 9 months lordship.
23.
Item 17.
17, 23.
Item number 29 and 30, it may second April by. Protest matter.
10 and 30, 2nd April.
Lordship, item number 58, Lordship, is a revocation of probate matter, Lordship. At our instance, the matter has been listed. There is some urgency in the matter, Lordship. Can it be taken up any day in the next week, Lord?
Next week.
Tuesday or Wednesday, Lordship, any date can be fixed.
Wednesday.
Yeah. My lord,
Listing is not a problem, but it has to reach.
can it be? Item 18, can it be?
Item 18. Huh? Tuesday. You want it on?
I want it on Thursday,
I plead lordship.
That will be which date? Just be
26.
26th.
Item number 55, 56, 57. Five lordship. Can it be fixed on Tuesday?
It has come.
6 and 57, my.
Tuesday.
Yes,
Not a
please,
problem.
lordship. Item number 44. 5, my lord.
Item?
Item 44.
Acha. Okay.
25th. Item number 34. 34, lordship.
Next week or thereafter? Let it be on Monday, 23. Sorry, the 30th April. Have some urgency? Okay. 30th April. When? Which day?
Item number 31, lordship, kindly allow the interim to continue.
Interim will continue. All,
May I please
we'll
proceed?
check and extend the interim.
The item number 51, Your Honor. The matter is listed twice but not reached, Your Honor. Can it fix in April, first week of April? And
May it please, Your lordship, my lord. My lord, item number 24, my lord. Matter is amicably settled between the party, my lord. My lord, kindly may be listed on my lord 26, my lord. Oblige, my lord.
23, can it be 30 or 31, Mark?
26.
23, my lord.
Messi appeal. Cross objection. 30, 30.
30, 31, any day.
31. Take the dates, remaining dates. Take the dates.